Give the notice to the other side.
Yes, I should give the notice to the other side.
Give. If he comes, we'll take up. Don't worry.
My
If
lord,
he comes, we'll take up.
Can take more.
my lord, under extenuating circumstances.
You give a notice, come, tell us that he is here. Don't worry, we'll take up immediately. Come. Yes.
Lordship, may I be
My lord,
Yes.
under extenuating circumstances, my lord, I'd made this mention prior, my lord, but again I have come back to trouble your lordship a bit. My lord, it's the plight of a 4-year child inborn, my lord. The mother is a habeas corpus matter appearing in 240. I was waiting yesterday, but I didn't have my luck. My lord, if your lordship takes up this matter anytime today, upon notice I am mentioning this matter.
Who is appearing for the other side?
My lord, Mr. Prabha Mukherjee is the senior counsel.
Yes, come tomorrow. Come
Tomorrow.
tomorrow.
My lord.
Give the number.
My lord, item number 240 of today's list.
240. What rectification? Names.
Lordship, may I be permitted to mention for application? Lordship, I mentioned it in the last Monday, but it did not come into the list.
Yes.
Lordship, the respondent.
Give.
Lordship,
Whatever urgency we'll take up. You give a notice to the other side.
grateful.
My lord, for upgradation, my lord.
Give notice to the other side. Yes. Yes, call.
To my lord, this is my appeal. I am led by Mr. Shivashish Ghosh, my lord, who is online. He is online before your lordship.
I am for the appellant, my lord. My lord, I have mentioned this matter before the lordship. On the ground, my lord, I challenge the order of the London single judge refusing my case to pass an interim order in the appeal. My lord, I tell you, lordship, my lord, what the facts of the case. Then, my lord, I show the order of your lordship, my lord.
Where is the order?
21st,
Where is the
my lord,
order?
that
At page 12 of the stay application, my lord.
Memo it does not contain.
Yes. Memo it does.
Yes,
I'm
just
sorry.
wait.
my lord,
Just what? Give us 15 seconds.
please.
Yes, what is the matter about?
Now, I tell you, lordship, my lord, my client is a contractor, my lord. He has obtained the contract on the basis of a notice inviting tender on 21st of January 2022 for a period of 3 years for cleaning and housekeeping services for the respondent number 3 North Bengal.
When notice inviting tender, when the contract was awarded to you?
21st of January 2022.
21st January 2022. Then
my lord, on 12th of October 2022, I have been successful bidder in respect of that contract. Applicant was found successful and won the bid for the opposite tender written by respondent number 3. And thereafter, 14th, 12th, 14th, I was asked
sorry,
to
can
take
you
charge.
please? I am unable to hear him. Yes.
Madam, am I audible to lordship, madam?
No, you are audible, but there are a lot of disturbances here, so we can't hear you.
Oh, I'm sorry, madam. On the 14th of October 2022, I was given the contract on the basis of the notice inviting tender.
Yes. Look at the plight of this connectivity. What to do, sir?
May I, my lord?
The system got hanged.
May I continue?
Yes.
Yes. Yeah. My lords, at page 43 is
No, madam,
Mr. Ghosh, you are not audible. রিকানেক্ট করতে বলো আর কি বলবে। লগ অফ করে দাও ওদের ওনার। What is the matter? 21st of January 2022,
Yes,
you participated in the tender
yes, I participated in the tender, my lord.
and you have written a word that you won the bid. Winning of the bid.
I was
So-
declared as a successful.
So why you said won the bid?
I apologize, my lord. Actually,
Language must be very, yes, the language has to be very,
I stand
Yes.
corrected, my lord.
then what happened?
My lord,
No, my lord, no, my lord, your lordship.
Yes,
My lord, okay.
again. Mr. Ghosh, it is a network issue. We can't see you. We can't hear you.
otherwise the Wi-Fi connected and the principal bench is now very good. It has been provided.
No, no, my lord, am I audible to your lordship now?
Yes, audible.
My lord, I just, the difficulty, my lord, facing, my lord, there is some network problem here, my lord, that is the reason not possible I am now audible to your lordship.
Mr. Ghosh, you are sitting in a courtroom. There are a lot of noises coming from your behind. What can be done? We can't hear you clearly.
My lord, yes. My-
What
my lord,
can be done? You have to sit in your chamber and then do it.
the difficulty is, my lord, due to my personal reason, my lord, I have to come back here. Otherwise, I would have dared to assist your lordship, my lord. Kindly bear with me for 10 minutes, my lord. I shall be, for 10 minutes, my lord, I shall be facing the case. Thereafter, Mr. Bhattacharya will take it over, my lord. If your lordship kindly please.
What he says, I can't.
He is, my lord, praying for a short passover of 10 minutes, my lord. I
No,
think
no, I'm not paying for, no, no, not Passover, not Passover. I'm not paying for any Passover, my lord. Your lordship kindly hears me, my lord. Hey, Mr. Bhattacharya, you carry on with the matter. Kindly you carry on with the matter.
may I? Yes, may I, my lord? Lordship, after this, my lord, on 12th of this October 2022, at page 93 of my stay application, my lord, I'll apologize. There are multiple pagination. My lord will kindly consider the page number written with the prefix PG.
Yes.
PG 93, my lord. 12th of October 2022, my lord, this is the acceptance of tender in my favor. This tender was, my lord, for the purpose of cleaning and housekeeping services
Correct.
at North Bengal Medical College, my lord, at Siliguri.
Yes.
My lords will kindly turn to the next page, page 94. This is the work order issued in my favor, dated 13th of October 2022.
Yes.
Now, the subject is, what is important, my lord, here is that it is for cleaning and housekeeping services,
For a period of 1 year,
1
it
year,
was given.
extendable
Up to 3 years.
up to 3 years.
Yes.
And my lord, 285 unskilled plus 3 semi-skilled, totaling to 288 personnel, my lord. This is also very important number, my lord. Now, after I started working with lordship, I performed my work satisfactorily. If your lordship kindly comes to page 98. My lords are there? Yes. This is dated 2nd of August 23. This is a work in progress certificate given in my favor by the medical college authorities. my lord.
Correct.
Now, I was doing this work prior to this contract, this tender. I was there. My lords, kindly comes to the next page. Here, my lord, a satisfactory certificate has been given for my performance during the COVID period. Though, my lord, it is outside the purview of the present tender by which I am working, my lord. Now, what has happened in the meantime, individual satisfaction were also given to the personnel who were employed by me. Now, due to inadvertence, my lord, those were not made part of the writ petition, but subsequently through a supplementary affidavit, it was made part. If your lordships kindly comes to page 167.
So you were discharging satisfactorily. That's the point you
Yes,
want
that is
to
the
make.
point. Yes, my lord.
Yes, then
Now, my lord,
what is the grievance? I just
grievance,
want
my
to.
lord, is the termination of my work.
Where is that order of
Yes.
termination?
Yes, my lord. This is, my lord, at page 108, 108, PG 108, my lord.
Yes.
Yes.
That is the
Dated
13th of
13th of
August,
October.
2023.
13th of October 2020.
Sorry, October, yes. Extended for 3 months.
Yes, my lord.
Yes, then the
reason
November,
given-
December and January.
Yes, the reason given, my lord, this has been done for the interest of patient care services.
Yes.
Now, why this has already all of a sudden come up, my lord? Now, before your lordship kindly takes this, I'll take your lordship to some of the conditions of the tender.
Contract.
Yes. If your lordships will kindly come to page 78 of my stay application, my lord.
Yes.
My lords are there. My lords will kindly come to clause 10, termination for default. 10.1, may I please it, my lord?
Yes.
The purchasers without prejudice to any other contractual rights and remedies available to it, the purchaser. Here purchaser is the medical college.
Yes.
May by written notice of default sent to the contractor, terminate the contract in whole or in part if the contractor fails to deliver any or all of the goods and or perform the services and or fails to perform any other contractual obligations as specified in the contract or within any extension thereof granted by the purchaser pursuant to the GCC subclause 8.3. Pausing here for a moment, my lord, I'll take your lordships to 8.3, which is
Same
in that
page.
page. Yes, madam, I'm placing it. If at any time during the currency of contract, the contractor encounters conditions hindering timely delivery of the goods and or performance of services, the contractor shall promptly inform the purchaser in writing about the same and its likely duration and make a request to the purchaser for extension of the delivery schedule accordingly. On receiving the contractor's communication, the purchaser shall examine the situation as soon as possible and at its discretion may agree to extend the delivery schedule with or without liquidated damages for completion of contractor's contractual obligation by issuing an amendment to the contract. Now, my lord, will kindly come to the next page, page 79. This is clause 11. Second termination, which purchaser.
That was in case of an insolvency.
Yes, my lord.
So
And my lords will kindly come to clause 13. At the same page, termination for convenience. I'm placing it, my lord. The purchaser reserves the right to terminate the contract in whole or in part for its purchaser's convenience by serving written notice on the contractor at any time during the currency of the contract.
So it's an unbridled right which is given to
Yes,
them.
my lord. But the next line is very important in my
So,
humble submission.
Yes.
The notice shall specify that the termination is for the convenience of the purchaser. So
Correct.
therefore, my lord, my humble submission is if my contract is terminated for convenience, the termination has to be very specific that it is for the convenience of the purchaser alone. In accordance with clause 13. Now, my lords kindly sees, my lords have been pleased to see my termination. Now, my termination, if I'll trouble your lordship again with that at page 108. My lords are there.
Yes.
This has been done for the interest of patient care services. That is the reason given, my lord. It is neither performance deficiency, nor insolvency, nor for convenience.
No,
For a new clause.
No, Mr. Counsel. There are two aspects of the
Lord.
matter. One is there was a contract for a stipulated period or a specified period.
Yes, my lord.
The contract is extended by this particular notice for a further period of three months, which is as per the terms of the contract which is there. They have extended it. It does not talk about that the contract would be extended for any other period or a specified period. It says up to 3 years it can be extended.
Yes.
So now they say that yes, we are extending it, but we wanted to initiate a new tender process.
Right.
So it is not really a termination. It is really an extension of the services which has come to an end by efflux of time, nothing more than that. Can you term it as a termination?
My lord,
Because your contract period was up to
2025.
2023.
Total tenure.
No, this was extendable up to the
Extendable?
period
Yes,
of
my lord.
3 years.
Subject to satisfaction.
Whatever. So this is what is that it, and secondly, it is at their discretion whether to extend or not to extend.
My lord, I'll beg to differ from your lordship on this point here, my lord. Subject to
then-
their discretion, subject to my satisfactory purpose.
No, where is that?
Yes, my lord.
Where is that?
Yes, kindly comes to, my lord,
Where is that?
I'll tell you.
That it has to be extended up to
Yes.
3 years, not be,
No, not 3 years.
so
Annually, subject to
Correct.
satisfaction. my lord.
suppose if the extension is not denied, is denied,
Right.
what will happen? Can you claim that yes, your services has to be extended?
My lord,
If they say that yes, I am hereby extending for another period of three months,
yes.
that is there within their discretion to exercise that discretion.
Subjective discretion.
No
my lord.
stigma has been put on that. The earlier paragraph has to be seen at page 108,
Yes, my lord.
which says that extended for 3 months or until finalization of a
tender.
new tender process for supply of cleaning. So they
Yes.
wanted to have the fresh tender for this purpose because the term period has expired. Had this notice come within that 1 year period, you are absolutely correct. You have a very strong case on that.
Within that,
No, this is not within that.
I'll
It
tell you.
is says that we are extending it, but we wanted to, I think, take an exercise of new tender process.
My lord, the work order was issued on 13th of October 2022.
Correct. So for a period of 1 year.
1 year.
So 1 year is expiring.
Yes.
If we go by anniversary to anniversary, then 1 year expires on 30th of October,
13th of
13th of October. They have extended it for another period of 3 years and also said until finalization.
October.
So I do not know whether they have finalized it or not. Have they floated a tender or
Yes,
not?
yes,
Have
they
they
have,
taken
they
any
have.
steps or not?
They
They have to do it.
They have.
Unless they finalize it, this is there. You
lord-
participate in that tender.
lord,
Where is the difficulty?
My lord, kindly for once comes to page
No,
43, my lord.
Huh? Yes, obviously.
My lord, kindly,
If it is a stigma, they have a right. They have a right.
my lords will kindly come to page 43 once, my lord.
Yes.
PG 43, my lord. PG 43.
Yes.
Yes, this is the tender document, my lord.
Yes.
My lords, are there, kindly see the first part. The medical superintendent such as such,
For providing a cleaning and
Yes.
housekeeping services for the medical for a period of
3 years.
3 years.
Renewable at end of each financial year of satisfactory performance, my lord. So the condition precedent is that my renewal depends on my satisfactory performance. And even after, my lord, this 13th of October letter was given to me.
What is, Mr. Ghosh knows better. What is the meaning of the word renewal?
My lord, it has to be renewed by the,
What is the meaning of the word? Mr. Ghosh knows.
where is he?
There was a lot of, the arguments which was advanced, and he was my adversary at the bar in that matter.
This is the reason, my lord, there are the network glitches.
And matter traveled up to the Supreme Court.
Sorry, I'm not aware.
My lord, may I please?
May I give you some academic purposes? There was a lease for a period of 15 years, and the lease contains a renewal clause or the extension clause. The question that arose was, because I was for the lessor and Mr. Ghosh was representing a lessee. The question was, two questions was there. That first question is that, what is the meaning of the word renewal or extension? If the lessee exercises an option, it gets renewed. Then what is the difference with the word extension? The argument from Mr. Ghosh's side, now I am taking that argument against him. What he took against me there. The argument of Mr. Ghosh was that renewal, if we dissect this, then it comes a re-annual. Re means again, and newal means afresh. So it is really a fresh lease which has to come. If the fresh lease has not come, because if the lease is more than 1 year, then under the Transfer of Property Act, it has to be done by a bilateral document and cannot be done unilaterally. So since I was allowed to continue and it was a renewal, so I have got a benefit of this particular period, which is a fresh period of 5 years. And therefore, 15 years period will not be counted for that. It will be only counted for 5 years, and that too without any bilateral document. So I come within the purview of West Bengal precedency here. I am protected.
My lord's argument
Was that no, you are still under the Transfer of Property Act.
because it is for 15 years.
Then it is for 15. Then we said 15 plus 5 or a 20 years. What is to be done? Luckily, he was correct in his argument. The court holds so. But our lease contains an extension clause. So my argument was that it is not a case of a renewal, it is a case of an extension. And the extension connotes something which sprungs from the original, some things which arise from the original, something which flows from the original. Extension means what? It is extended. So original things are there, only elongation. This is the only thing. So it does not require any kind of a fresh lease to be entered into.
Here is extendable. my lord.
There was a dissent in the division bench. Then the third judge held in my favor. Matter went to the Supreme Court. Ultimately, Supreme Court also held in my favor on the score of extension.
This is also extendable. up to 3 years.
Now, when you said renewal, then renewal connotes a reciprocal agreement between the parties. And it will be treated as a fresh. Then I can give you a judgment. 1970 Supreme Court, Delhi Development Authorities case. I argued that in 1995 and 96. Still, I remember what I have argued. Second is the subsequent judgment of the Supreme Court in Provas Doloi's case. Probably 1988 or 89 Supreme Court. The second judgment is very apt, where the Supreme Court made a distinction between a renewal and the extension. Both. So you can't take advantage of renewal. Renewal connotes the reciprocal agreement or a consensus. And it will be regarded as a fresh
It is
term.
bilaterally done.
Extension means that has to be extended. And the extension says, the clause, I can understand, extendable
Extendable.
up to 3 years. Extendable means what? Means is still at the discretion of the person whether he will extend up to 3 years, may not extend up to 3 years. Here he has extended up to 3 months.
Subject to my,
No, nothing.
subject to the satisfactory purpose.
No. Renewal is a satisfactory performance. Extension does not. Right.
All right. But here today, my lord, we
So
are,
Mr. Ghosh will not argue that.
my lord, we are, my lord, we
Have
are.
you got that Provas, Provas Doloi's case?
My lord, we are, my lord, aggrieved by the refusal of an interim order.
Interim order can only be passed on a recording a prima facie case to have been made out in your favor. If you can show us a prima facie case, then we can definitely pass an interim order staying the entire process of tender which they have undertaken. But there must be a very strong case in this regard. After all, it's a contract, and you know the writ jurisdiction in a contractual matters are very limited. I know ABP,
ABCL.
international that
ABCL. No.
AB,
ABCL. No.
no,
not ABCL.
ABC International Limited by Justice S.B. Sinha.
My lord, here, one aspect, if your lordship kindly considers. I understand what has fallen from your lordship. Kindly see the timeline when it was done. What has happened, my lord? That out of this 288 personnel, my lord, only 100 to 110 were allowed for the housekeeping and cleaning services. The rest, my lord, in contravention of this contract, were being utilized for other work. Now, my lords were pleased to see clause 8.3, my lord. I agitated it. If your lordship kindly sees, my lord, on 9th of October at page 105, PG 105, my lord. My lords are there? Yes, I'm placing it. A request for enhancement of cleaning and housekeeping staff at North Bengal Medical College. Reference was to that tender, my lord. I am coming to the second paragraph, but at present, 203 numbers of GDS staffs have been deployed at 3 shifts in various wards of North Bengal Medical College, and 110 numbers of cleaning and housekeeping staffs have been deployed at 3 shifts at various North Bengal. The details of deployment is annexed here. In the above connection, I would like to inform you that 203 numbers of GDS staffs have been engaged in for general duty for various wards, and only 110 numbers of cleaning and housekeeping staffs have been deployed in 3 shifts for cleaning and housekeeping service at various wards and surrounding of the North Bengal Medical College. The 110 number of cleaning housekeeping staffs is
No,
insufficient.
that is you raise. Suppose if you say
Yes.
that your performance is not satisfactory, then you have a very good case in this regard that yes, I am deploying 203 persons, but you are utilizing the services of only 110 persons.
This goes
So
unanswered.
naturally, the shortage of manpower, utilization of the less number of manpowers, that cannot be projected against you as a deficiency in service. I can understand that. But here, that is not a case which is coming under that.
That letter of 13th of October 23, my lord,
Uh,
says in the for the
You
interest of
get
patient.
it done.
Interest
Have you
of patient.
participated? Has he
No, I have
participated
not
in the
participated.
subsequent? When the tender was floated and when
It is kindly come to at page 100, my lord,
No, not
111, my lord, 111,
triple.
which they
very
have written
dicey
PG.
number,
Yes,
dicey
PG.
number,
PG, that's the.
Single Nelson number or something.
Nelson
I forget
number.
It is called.
Yes.
This tender was floated on, my lord, 16th January 2024.
Yes.
And last opening of the technical fees, my lord, that was 19th February 2024. So option was there, he could have participated in the tender process.
You have not been able to open it.
No, actually we are in process because there is no such restraining order. We are in process of.
But you have not opened the technical bid on 19th.
My lord, we have opened the technical bid on it.
And the financial bid you have not.
Financial minute, I have to take the instruction. My lord, what is the
No.
technical
To be announced later
bid? To be
on.
honest,
You have
maybe
not.
maybe
You
it
have
has-
not.
Maybe it has been. Maybe it has been. Today we are
Because after the opening of the technical bid, everything, then you'll have to upload it.
up within 7 days period.
So that to be
Today,
announced
19th
later on.
plus 7 would be a.
To be announced
26.
later on means you have not announced
So
it.
that's
yet.
why I said I have to take the instruction.
No
within the
instruction.
financial.
You have not.
And my lord, there is an arbitration clause even in the same
No, but
contract.
then my lord, know that arbitration clause is not a bar in respect of a petition. Yesterday, my
There is
lord,
no bar.
yesterday, my lord, in another
In a-
case, it fell from your lordship that
In a writ.
it is
Because my lord, it's
It
Tata
is a
Cellular case,
discretion-
it has been well settled
No.
in which circumstance the writ courts are entertained
it is a discretion more
with regards
not
to a particular
compulsion.
tender.
Yesterday, my lord, it fell from your
We
lordship.
are conscious of the situation. It does not create any absolute bar into the court's jurisdiction.
My lord must have used that phrase. It is more of a discretion than a compulsion.
My lord, when the writ court will entertain, when it has been the certain guidelines have been set.
Sorry, that ABC not, that is a ABL international.
ABL International.
Then thereafter, my lord, there is a
There's an
Tata
ABL.
cellular, the proposition is Tata cellular.
The first, the
Yes,
first
yes.
foundation
Yes, my lord,
in a contractual matter is the ABL international.
yes. And my lord, if your lordship see in the first tender process at page, my lord, that is an absolute.
No, we are just thinking whether some relief can be given to him
He has no
in that.
question opted, how can,
That is what.
My lord,
he has
Regard-
missed the bus.
regarding-
You would have participated without prejudice to your rights, but
my lord,
the difficulty is this, you could have.
my lord, I understand, but today, my lord, that the situation is that the honorable single bench was pleased to, my lord, admit my writ petition.
ওটাই আমি চিন্তা ভাবনা করছি, ওটা চিন্তা ভাবনা আমি এই জন্য একটু ভাবতে গেলাম কিন্তু টেকনিক্যাল ওপেন হয়ে গেছে, আপলোড করে দিয়ে ফেলতে পারেন। Upload হয়ে গেছে।
My London single bench was pleased to admit my writ petition.
It does not mean. For that reason, sir, the amendment has been brought in 2002 in the Code of Civil Procedure.
1980.
Order 41, Rule 5, Order 40, or 115. Why amendment? That mere filing an appeal will not tantamount to stay.
No, it
So
will
even
not,
if
it will not.
appeal is admitted, that does not
No.
mean that there is any
No.
fetter.
Since, my lord, the interim protection was
Whatever
not
intent,
granted,
that is what I say.
may I,
And
my lord,
obviously, every action would be subject to the result of that writ petition, whatever.
And my lord, this Deloitte judgment was 1989.
I said it, 1988 or 89, I
Well,
told you.
And there is a distinction, it has been made extension and the word of renewal.
I know
That
why
you also
I
said it.
told you.
my lord, the loss will be, my lord, irreversible.
What can be done? Merely for that, you have to establish some right. I am unable to comprehend as of now that under the contract, whether you have that particular prima facie case to go on.
My lord, satisfaction is the,
No, that
Not
is not.
basic,
We will
my lord.
make, if you want, we can make a distinction that satisfaction in what sense and the extension in what sense. And then we'll have to rely upon those that the renewal, what it constitutes.
because my understanding was that satisfaction is the primary
No,
consideration.
no.
And
no.
the
For the purpose of renewal,
yes,
not for the purpose of extension.
extension. And my lord, it is also a non-speaking, my lord,
Should not be. Why it should contain a ground for they have rather they have assigned that we wanted to undergo with a fresh tender process. Anyhow, it will take some time. We are extending your period for another period of 3 months.
Till
That's the only thing.
Or till the final.
Finalization.
by a, my
It is
lord,
not a punitive, my lord.
non-speaking,
It is not punitive.
Extension is speaking, no.
my lord, my rights are getting.
What
increased.
right you have? I was really wondering and pondering upon that what right you have. A contractual right for a specified period has come to an end. Then what right? I just wanted to know. What right?
My lord, again, my lord, I will be repetitive, my lord.
No, this is not. Is a renewal. The instant appeal. We are disposing of the appeal. Keeping this appeal pending is of no use. the instant appeal arises from an order
Page 12.
dated 13th February 2024, passed by the single bench in WPA 191 of 2024, whereby and whereunder the prayer for ad interim order,
Not interim, my lord,
the
interim.
prayer for interim relief was rejected. Admittedly, the petitioner was declared successful in the tender process invited on 21st January 2022 for the purpose of providing cleaning and housekeeping services in North Bengal Medical College and Hospital. Subsequently, the work order was issued
Work order is at page 94, my lord.
I know. The work order was issued on 30th of October 2023, which clearly envisages that the aforesaid tender is awarded for a period of 1 year with effect from 14/10/2022 to 13/10/2023 and extendable up to 3 years. There is a specification of the number of the manpowers to be supplied for such purposes. And it is not in dispute that there was any deficiency in performing the contract so awarded to the appellant. Rather, the appellant was allowed to provide services for the entire period of contract so awarded. And the dispute and the origin of the dispute can be seen when a letter dated 13/4,
10, Lord.
13/10/2023, that is at page 108.
my lord.
13/10/2023 was issued by the respondent authority, extending the period of services for a further period for 3 months or until finalization of a new e-tender process. The aforesaid letter dated 13/10/2023 is construed by the petitioner as a termination letter, and the challenge is founded thereupon on various scores, including that the term of the contract was for a period of 3 years, and therefore the decision to initiate a e-tender process in the midst of a contractual period tantamount to an implied termination of a contract without assigning any reasons therefore. Our attention is drawn to the various documents annexed to the application for stay to buttress the contention that the authorities all along issued the satisfactory certificate, and therefore there cannot be any deficiency in providing the services for which the contract was awarded. However, our attention is drawn to a letter where the manpower supplied by the appellant for the purpose of
Cleaning and housekeeping.
cleaning and housekeeping services are utilized for some other allied work, some other purposes. And the issue was raised by the appellant that utilization of such services with the less number of manpowers cannot be construed as a deficiency in service. We are not ventured to go into the aforesaid aspect after looking at the letter dated 13th October 2023. The captions which can be captured from the bare look leaves no ambiguity in our mind that it is an extension order where the services of the petitioners have been, where the contract awarded to the petitioner was extended for a period of 3 months. Or until finalization of a new e-tender process. Though it is also written that such extension is written that it is in the interest of the patient's care services. But the same has to be understood in the perspective of extending the period of contract and cannot be perceived as a ground for termination of a contract. The counsel for the appellant puts much emphasis to the terms of the tender inviting the notice inviting terms of the notice inviting tender. Wherein is it indicated that the said tender is invited for providing cleaning and housekeeping services in the said medical college for a period of 3 years, renewable at the end of each financial year on satisfactory performance by the bidder. It is sought to be contended that the contract was in fact awarded for a period of 3 years, renewable at the end of each year, each financial year, subject, however, to the satisfactory performance of the bidder. Taking a clue from the above, it is sought to be it is urged that since the authorities themselves issued the satisfactory certificates, it is imperative, it is imperative on them to renew the said contract.
Well, the satisfactory performance not with regard to his contract.
Please renew the contract at the end of every financial year. We find a distinguishing feature between the terms incorporated in the notice inviting tender and the work contract issued to the petitioner subsequently. even if we accept the contention of the appellant that the outer limit for the contract was provided as 3 years, but such outer limit is dependent upon the factor relating to satisfactory performance at every financial year. The renewal does not connote the extension as they are distinct and operate in a different field. The renewal is always considered as an element of a fresh contract and or agreement to be entered into on the expiration of each financial year, semicolon. On the other hand, the extension means something is stretched further or elongated further and or arising out from something already in existence or flowing therefrom. In fact, the respondent authorities invoke the consent of extension, and the period of contract was extended by 3 months or until finalization of the new e-tender process. And therefore, we do not find any infraction and or violation of the terms incorporated in the notice inviting tender. It cannot be said that the respondent authority, it cannot be said at this stage that the respondent authorities have acted contrary to the terms of the contract. Full stop. We thus do not find that in order to pass an interim order, the guiding principles are that the petitioner must make out a strong prima facie case and must also prove that in the event the interim order is not passed, it would cause immense injury. And therefore, the balance of convenience and inconvenience lies in passing such interim order. We are conscious that in order to find out whether any prima facie case is made out or not, the court has to enter into the cause of action so pleaded and the right of the petitioner, which appears on the meaningful reading of the documents. Full stop. Since we do not find any prima facie case having made out for an interim order, consequently, there is no illegality and or infirmity in the impugned order. The appeal is thus dismissed. However, it is made clear that the findings made herein above is a prima facie finding relatable to an interim order and shall not have any persuasive effect on the merit of the case at the time of final disposal.
Good.
All of the affidavit of service.
Constable? Next circuit.
Item 3 and 5, this matter, my lord. The lordship was pleased to told me that ensure another Vokalotnama. The appellant shall file this appeal and another by the jail authority, my lord.
File it in the department.
Yes,
They, Mr. Hillol Saha Poddar appeared in the instant matter and submits that though the instant appeal was filed by his client directly from the jail, but subsequently he was engaged to file an appeal against the self-same judgment. And therefore, both the appeals should be tagged together and be heard analogously. We find that the instant appeal, though filed by the accused from the jail, but subsequently CRA within bracket DB 6 of 2024 was also filed by the same appellant through Mr. Poddar, and therefore let both the appeals be heard analogously. The formal order of admission, lower court record, paper book. Both order is in 3 and 5. It has to be admitted, it's a statutory right. So,
for the appellant. The legal service matter, the last operation, I have filed the section 5 application, 329. Section 5 application, I have filed.
Regarding my lord, legally the authority he appointed that file this.
where is section 5?
I have filed.
Where is that?
Can one.
Where is Can 1? Arey Babu, where is Can 1? কোথায় আছে যা বার করো নেই কোথায় জাজমেন্টে কপি এটা মেমো where is Can 1? এখানে দেখাচ্ছে Can 1. Call it from the department, just short pass over.
No.
Let it come. এই এক্ষুনি আনো department থেকে। Just call the next.
Actually, this is a bail application because as the matter relates to SC/ST atrocity.
No,
Act,
it is an admission.
it's a bail application.
No, appeal has to be admitted unless the appeal
Well,
is
the
admitted,
admission
the bail.
On last occasion of the lawsuit was pleased to heard the
No.
admission was not done.
So admission has to be done. Unless it is admitted, it is not regularized. And then bail application
Yes, madam.
in that.
My lord, I do.
Hey,
Yes.
is not.
So this is a bail application. This is not an appeal against the conviction.
We can hear out.
On the last occasion, they took time to produce the case there.
Oh, it actually the order rejecting their bail application. This is how they have challenged under these atrocities act.
STS.
It is
Actually,
applicable.
14(2)A,
Yes.
14(2)A gives us that is also
Then
file
applicable.
application.
My lord, can you fix it tomorrow, my lord? Can you fix it tomorrow? Because I need to go to the case study and I need to see the sections also properly, whether it is.
No, it is, I remember,
Yes,
they
sir.
were saying that the order refusing or granting the bail is an appellable one. So they have really filed the appeal against that order. It is
14.
under the Atrocities Act.
Atrocities
My
Act,
lord,
my lord.
So
14(a)(2), my lord.
whatever, so that right is there.
Right.
So appeal has to be admitted, there is no doubt about it, but this is concerning the bail, unnecessarily keeping the appeal pending will not do it.
Tomorrow you can get.
So you do it at the time of admission, we can dispose of the matter. Unnecessarily will not keep
My
it.
lord. Actually, that
Tomorrow?
is the basic problem we are facing.
No,
Because
not
we have to face file the appeal.
No, it's not. Okay.
We'll make fix it tomorrow.
He wanted to go through the voluminous case diary,
No, I go. Because this case led to 2022.
whatever.
Well,
Next,
one in that is I'm 6 months. Tomorrow I will permitted to appear to actual more because I will be after.
sir, I am always in favor of the hybrid hearing. There is no difficulty, provided connectivity is seamless.
My lord, I will. I will be out of station too.
Yes,
Because item number 7, I'm for the petitioner. This is suspension of sentence, my lords, bail in connection with appeal. Conviction.
no, first thing is the admission has been done or not. So it has to be admitted and then the application.
My lords.
Let it be admitted,
Delay has been condoned.
condoned,
Yes, last occasion.
admit.
Admitted.
My lords, it's a POSCO case, my lords, it's a live streaming. my lords.
What?
It's a POSCO case, the live streaming may be possible.
Oh, sorry, hey. Yeah, yes, true.
Then.
Who has filed the cancellation? Where is the order for granting bail? Page. Page. Just 1 minute. So he is the brother of the deceased.
Yes.
No, Uttam.
Yes, no. Subodh right. And his wife.
No, she's, no, Uttam is, it is really, he is the brother of the deceased Aparna Bhattacharya.
Yes.
He has been granted bail.
Followed he
You are selling this order, 13th September. Then which order?
Last November 2020. Last decade. Second starts on.
1st November, just, I'm unable to get it.
Last
1st November, yes. This is Shoikot.
yes.
So there are 2, 3 grounds. First thing is that he has cooperated in the investigations. Then his name is appearing in column 13 of the charge sheet. And therefore, the court was of the view that he should be granted bail. No. Just, that is his application, sir.
Initial stage.
Have you not annexed the charge sheet here? Have you been given an opportunity to file your? He has an he has a right to file the opposition. Can we see the charge sheet?
Yes. Page 137. Column 30.
So the name has been given at first witness.
You are on that point of time, not charge sheeted because.
No, your name is given as first, and where is his name?
Column 13,
13.
page 137. Particulars of accused person not charged. What such?
Where I do not find particulars of the person not charge sheeted, yes.
Honored, yes. Honored,
Absconding,
honored, kindly bracket put some suspect. And honored,
Where-
150,
where bracket portion I am.
suspect.
Oh, upore, yes.
Honored, thereafter kindly came, honored, Roman 15.
Oh, his name is there.
Yes.
His name is there, yes.
Roman 15, kindly go to Roman 15, the same.
Roman 15.
Yes, kindly go to. As special remarks, including remove or not charged in investigation and incorporate against this accused.
Then
person
why
and
absconding? He is,
He custodial on that point of time, he was absconding
okay,
followed after rejection of anticipatory bail by this honorable
correct,
and also Supreme Court.
correct.
And one
Then-
at that point of time,
Yes,
followed, he was kindly go through that, Roman 15.
yes.
Followed, kindly go through passed by this honorable court anticipatory bail rejection. Bail.
Opportunity has to be given.
Page 59.
Anyhow, he has to be given an opportunity, otherwise. This is an application for cancellation of bail. Granted to the respondent number or the sole respondent. No, not private opposite party. The opposite party number 2. By the CJM Jalpaiguri on 1st November 2023. The copy of the application have been served upon the opposite parties who are represented before us. Stop. Since it relates to a cancellation of bail granted to the opposite party number 2, he should be afforded an opportunity to controvert the allegations made in the instant application. In such view of the matter, let affidavit in opposition to the application be filed within 2 weeks from date. Reply, if any, shall be filed within a week thereafter. The matter is made returnable 3 weeks hence. Take back.
One more thing.
Take back.
My lord, I can be supplied with a legible hard copy. So this is download.
We are now on.
Some of it is are.
It's hard.
Nowadays, that is a problem with your printer. You can't blame him. If he has supplied a soft copy, then it is a very legible one. If your printer is bad, what can be done?
Portions of the order did not come.
I am already. Yeah.
Lago, for the purpose of record, it is recorded that the hard copy of the application for cancellation of bail has been handed over to the counsels appearing for the respective parties in court today.
I have already.
What I have recorded?
Yes, yes.
But he is appearing. This is, he has not. Service is incomplete. Let the matter appear before the next circuit bench.
Then, how about the petition? The matter was, the lordship was hard.
I was heard.
Those-
By whom? By whom? I was heard by whom?
His junior was.
No, you said your lordship was heard. I was heard by whom? By whom? Who heard us?
I did this.
There
There is a cancellation of bail. আমি বলিস না, আমি কি বলবো? আমরা তো আমি বলেছি, আমি বলো। Procedure apply to-
So let them file the opposition. A similar order, opposition. 2 week, 1 week, 3 weeks is. It's called the
Pursuing the previous occasion, the lordship department had- state government were directed to other city.
Yes, where is the state? Where is Mr. Aditi Shankar Chakraborty, Mr. Rojjwal? Where is it? Sir, what is going on? Are you appearing in a high court or appearing somewhere else? You are just shying away, you are going back. Is this a way the high court functions? There is a decorum and the discipline which is always maintained in the high court. I've got a strongest reservation in this regard. There must be a decorum. Everybody is taking a high court for a ride. Where is your document? Where is this? You are supposed to disclose. You were supposed to file report. Where is the report? Then your junior, what he is doing? I thought that the matter would not be taken up. Yeah, take it. না, assets টা কি আছে? আমরা কেন এটা অর্ডারটা করলাম? আগের অর্ডার ছিল মনে হয়।
More than 1 year after filing the complaint.
No, this is an application seeking a relaxation of bail. Now you were granted bail on furnishing a bond and then and meet the investigating officer once in a week till the charge sheet is filed and cooperate with the investigation. Now the charge sheet has been filed? Not yet. So what relaxation you want?
I guess that,
Why we directed the state to submit the report disclosing the assets of the petitioner? I also do not understand why this was granted. Why it was granted? Okay.
What business she's doing, what business he's doing? 10%.
Oh, he said that he is residing in a. He is presently residing where?
Which we are-
Kuchbihar district, my lord,
So,
along with his family.
so why you want a relaxation? Which condition you want a relaxation?
Relaxation cannot be given, my lord. Why?
Just don't hijack his statutory right to begin. He has filed an application. You have not seen Justice Anil Kumar Sen. You were not born.
That the terms for the state of law. When actually my petitioner is doing business for that purpose, he has to go outside of the territorial jurisdiction and to remain for more than 2 or 3 or 10 days also. Maybe. That's why we could not cooperate with the conditions. But till this he is cooperating. He is giving the Thana Hazira and till January, 6th January. But thereafter he is fasting some which I do not have Alex, because that duty is sustained after the filing of my petition. And
Yes.
more than 1 year has been lapsed after filing complaint of the complainant, but the charge sheet is not being lost. Section 173 of the Code of Civil Procedure, which suggests that without unnecessary delay, the charge sheet has to be submitted. But if the charge sheet has not submitted, why I could.
You are entitled to a statutory bail. There is no difficulty if the charge sheet is not filed within a time frame. So you have already been enlarged on bail. The question is of the relaxation of the conditions. Even at the time of statutory bail, cannot the court impose certain conditions? So court can. There is no difficulty. That is what we wanted to know from him. That's the only ground. What are the?
And the marginal.
Yes. Okay.
Every time I could not obtain the permission from the court.
Okay.
He gave the movie also.
Okay.
And I'm suffering from various delays.
But those documents are not forthcoming here.
But
But that cannot be taken into consideration unless it is brought on record. Can the court go by this? We'll have to say that what is there. And they have to cross-verify whether those documents have any sanctity or any kind of authenticity. Then is why you have not completed.
My IFSC report has been collected, my lord. Now
Why
my lord, the
FSL? This is
My lord,
not
the
under.
Arms Act, my lord.
Achha, Arms Act. Yes.
So my lord, IFSC report has been collected. Right now, my lord, the IO is waiting for the public prosecutor's opinion, my lord. You will be giving the charge sheet in due time, my lord. And my lord, against this accused, my lord, there are several, my lord, cases against him, registered against him, my lord.
How many?
Around 9 cases, my lord.
Under the similar provisions?
Under, my lord, 447, 325, 317, and other sections are there, my lord. And in Arms Act also, my lord, in one of the cases, Kotwali PS case number 185, serial number 8, my lord. Serial number 8.
The instant application is taken out by the petitioner, seeking relaxation of the conditions imposed while granting the bail by this court on 15/6/2023 in CRM within bracket A 394 of 2023. The earlier coordinate bench, while granting the bail, imposed the condition that apart from furnishing a bond, this was 438 too, anticipatory bail. Or 439. Anticipatory bail. Not bail বলেছি যেখানে উপরে relaxation of the conditions while granting bail বলেছি তো anticipatory bail.
Apart from furnishing a bond form.
The petitioner was directed to meet the investigating officer once in a week till the charge sheet is filed and shall not leave the jurisdiction without the permission of the jurisdictional court. And to surrender before the court below within 4 weeks from date and pray for regular bail. It appears from the record that in compliance to the said conditions, the petitioner has been granted a regular bail by the jurisdictional court. The instant application is taken out for relaxation of the condition of meeting the investigating officer once in a week and from leaving the jurisdiction with the permission of the jurisdictional court. Stop. It is submitted that the petitioner is a trader and have to meet the intending purchasers to whom the supplies are made, who are stationed in the different districts, and for such reason he has to travel at a quite distance and remain engaged for a period of 1 week or more. It is further submitted that till date the charge sheet has not been submitted. And there is a considerable delay in completing the investigation. Next one. The state, in terms of the direction passed on 19th February 2024, submits the report. It appears from the report that the antecedent of the petitioner. No, the said report, full stop. It appears, the said report revealed the antecedent of the petitioner and his involvement into various cases, including the offences for which the instant case has been registered. It appears to us from the same that he is a habitual offender. And even though the court has, even though the earlier division bench granted the anticipatory bail, but we do not think that the conditions so imposed appears to be harsh. We do not, the conduct of the petitioner does not instill any confidence in us that he would not flout and or violate the conditions so imposed in the event the same is relaxed. Full stop. Accordingly, we do not think that it is a fit case for relaxation. The application is rejected. However, we show our concerns in relation to non-filing of the charge sheet as of date. However, the counsel for the state submits that the investigation is virtually over and the charge sheet has already been, and the draft copy of the charge sheet has already been prepared, which requires a waiting from the public prosecutor, and assures this court that the entire exercise shall be undertaken within a short period of time. In such view of the matter, we direct the investigating officer to file the charge sheet as expeditiously as possible. Let them do it. Your conduct we have seen. What are you doing? For what?
But
কোর্টটা আছে পরে কল করে দাও।
may I submit for it?
What is this, sir?
But offense under, this is a bail application manner. But offense under section 302 and 356 of the Indian Penal Code. But this petitioner is in custody about 240 days. But charge sheet submitted, and my lord, my submission is that, my lord, the informant of this, the complainant of this case, my lord, is not an eyewitness, my lord. The case is based on the, my lord, circumstantial evidence. And what happened on 26th of June 2023, my lord, at about 7:30 PM, the informant received a telephonic information over telephone from his, my lord, wife, that she was attacked by the petitioner, and subsequently, my lord, the informant found that his wife was, my lord,
Where is
lying in
the-
a multiple injuries, my lord.
I am appearing for the de facto complainant in this.
But 164 statement, my lord, page 144, my lord. That is the deceased victim husband.
My lord, kindly see any eyewitness to the, my lord, any statement of the eyewitness, my lord. The informant is not an eyewitness to the, my lord, occurrence. And I am in custody about 240 days, charge sheet submitted, my lord.
Primary health center. In the morning, she got. Any other declare with the medical when she was there?
161 of the neighbor, my lord.
Sir, she was taken to the primary health center. Where is the document of primary health center?
My lord, that is on page 74, my lord. 123 and 74.
Multiple step one. কোনো document না ব্রড ডেট ছিল না where is the other document?
My lord, 139, my lord, kindly have a look. 139.
Well, kindly see the 164 statement of any of the eyewitness, my lord.
No.
The informant is not
hospital.
an eyewitness, my lord. But he is a, my lord, interested witness, my lord. As per the FIR, he is not an eyewitness.
Possibly kindly is the CDR also. From the charge sheet, it is appearing that CDR and tower location of the accused was also
That
collected.
does not mean he committed the offense.
And that shows that he was present at the place of occurrence.
Is the sole perpetrator of this particular petition.
Any recovery?
My lord, the
Yes,
model.
Lordship, my instruction.
Offending weapon?
My lord, page 12. And that ornaments has also been, my lord, that has been snatched away.
And that offending weapon has
Dagger.
sent to the FSL, my lord.
Black pocket. Black pocket is- Black pocket. Still with the- Okay. Have you sent it?
For FSL, it has been sent.
Any report?
No one, not
Then-
yet.
But I am in custody about, my lord, more
Lordship.
than 8 months, my lord. Charge sheet
Lordship,
submitted,
may I
but I will
submit-
face the
It
trial,
is-
my lord, at
it
any
is-
condition.
It is submitted by the counsel appearing for the petitioner that the petitioner is in custody for
240 days.
200 in custody uh, for 240 days and have been falsely implicated in connection with the instant case. It is further submitted that there is no material found during the investigation which may lead to complicity of the petitioner in committing the alleged offense. And therefore the petitioner should be released on bail. The state opposes the prayer for bail. It is submitted that the husband of the victim lady disclose the name of the petitioner in commission of an offense, and the petitioner is a sole accused accused in the incident case. So we had an occasion to peruse the case diary produced by the state. We peruse the statement of the husband of the victim lady recorded under section 164 of the CRPC, where he disclosed the role of the petitioner attributable to the commission of an offense as disclosed by her deceased wife, who suffered a grievous injury and ultimately succumbed to it. So we have further seen that scissor list, wherefrom it appears that the offending weapon was recovered from the position of from the back pocket of the petitioner, containing containing the stain of blood, and the same has been sent to the forensic laboratory in order to corroborate the same. Since the FSL report has not been forwarded by the laboratory as yet, but considering that the offending weapon was recovered from the position of the prisoner, and the other materials which are unearthed during the investigation, it does not instill any confidence in us that the prisoner is an innocent person at this stage and entitled to be released on bail. Accordingly, the application for bail is rejected.
Grateful to you, Lordship.
Offending weapon to offending weapon বলেছি তো it's called দিয়ে দাও so is the other side. What is this?
My lord, condemnation of delay my section 5 application.
Yes.
Jail of it may be admitted.
Has it come? Oh, yes. The instant appeal is at the behest of the appellants who have been convicted under section 5 within brackets Roman 2 within brackets small g and L of the POXO Act. And read with section and section 6 no of Kiburichi 5 Roman 2 G.
I'm praying for not today, kindly fix it on tomorrow. I need some instruction. It's a NDPS case.
What instruction?
The CFSL report is.
Your
not-
actual instruction is always postponed, later on received. What more instruction you want?
CFSL report is not in the CD.
Come tomorrow?
Yes.
I'm for the petition, Your Worship. Worship, this is the last order.
This is the last order.
No, yes, the last order passed by this bench only on 13th February 2024, where I was given the opportunity to move the case. Lordship. Now I appear pro bono, Lordship, because my name appears in the list of legal aid as pro bono to conduct cases pro bono. Lordship, from the
Have you-
petition.
Have you taken all reasonable
Yes, Lordship.
instructions? No
Yes, Lordship,
difficulty?
as available indeed, because in para number 13, they say the petitioner craves leave to submit and adduce documents required at the time of hearing. So those were written by the erstwhile lawyer. So from the, I keep my submission confined in the petition. Lordship, from the petition, after going through the same, I find only one point which can be raised before my lords, and that is in page number 10, if your lordship only sees the written complaint, the letter of complaint. The witnesses who were
No, whether this accused was contacted after your appointment?
by the legal aid authorities.
Yes.
No, I can't say, because they have given me the appointment along with the.
No, that I understand, but I do not know whether after appointment, whether you are required to take to consult your client.
I even don't know where it is. That's the problem.
Not commercial quantity. 309 grams of brown sugar, my lord, commercial quantity, all.
No, I was just thinking for his safety and, any kind of
Court has appointed, my lord.
that's true. We know, we have appointed.
My appointment letter and along with the documents was handed over to me by the concerned department.
There is in fact no.
Who was the advocate and record? Abhishek Sarkar, where is he? It
Last
appears that-
submission.
No, he did not.
No.
No, Abhishek Sarkar, High Court of Calcutta, Circuit Bench, Jalpaiguri, the mobile number is given. He's a practitioner here. So everybody knows him.
His senior is no. Whatever.
What is the point? Yes, yes.
Okay, only one point I have come across, only one point which I can raise before my lords for consideration. That is, lordship knows better than me that the witnesses of seizure and arrest has to be a respectable person of the locality. This was to justify the place of arrest and the evidences of the respectable person so that the case of the prosecution is established. Now here, what we find that it is mentioned, lordship, we have reached Hatighisha and search for two willing witnesses. After finding two witnesses, namely Sujit Adhikari, son of such and such of Nakshalbari, another Dinesh Singh of Haribari. So none of the witnesses are local, and I don't know regarding the respectable thing, but not local.
Trial.
So this is the only point I have found because the 50 notice was given.
Position is found with
Yes,
him.
from his possession. 50 notice was also there. As per the.
For the purpose of record, it is recorded that since last many occasions, several counsels for the petitioners appeared and asked or appeared only for the purpose of an adjournment. When this matter was taken up on 13th February 2024, we notice the conduct of the counsel who was representing the petitioner and passed an order that the petitioner may be represented by Mr. Saurav Ganguly, the panel advocate of the High Court State Legal Services Authorities. Pursuant to the said order, Mr. Ganguly have been appointed. Pursuant to the said order, his engagement has been regularized with a letter dated 16/2/2024. The moment Mr. Ganguly has been appointed, the Wakalatnama executed in favor of the erstwhile advocate stands cancelled. Full stop. Mr. Ganguly vociferously submits that there is a serious lapses at the time of the seizure. The seizure, as two independent witnesses of the locality are required to be present. But it appears that the name of the two witnesses as recorded in the seizure list are not the resident of the locality where the alleged incident occurred. The state opposes the prayer for bail and submits that the contraband above the commercial quantity is recovered from the exclusive or joint from the joint position of the petitioner. And in such view of the matter, the petitioner is not entitled to bail in view of the embargo created under Section 37 of the NDPS Act. Next, in view of the above, it transpires that so far as the name of the witnesses at the time of seizure as recorded in the seizure list is concerned, whether they are the resident of the locality or not is a matter of trial. So, since the commercial quantity of contraband is recovered from the joint position of the prisoner,
My lord, one indulgence, my lord. There were three packets, 103 rounds each from single.
Single.
That's why I asked if it is.
Three packets.
Sorry, exclusive position. Okay, joint position, how many? Exclusive position. The exclusive position of the petitioner. We do not find that the petitioner has make out any case for taking an exception to section 37 of the SEDA. Accordingly, the application for bail is rejected. Next.
My lord, I am for the petition.
I am for the state.
This is a renewal of prayer for me. Last time it was rejected on 3rd October, and after that, my lord, there is no development.
Then,
My lord,
if there is no development,
no development in respect of the stage of the trial. Charge sheet filed, my lord. If your lordship can you take,
how many witnesses have been?
my lord, in total 11 witnesses were there. Copy has not been supplied to, so for my instruction goes, matter has not been committed. It is a case of the royal section of 371. 2 persons are on bail.
What is this section?
To sail towards prostitute.
No, you use certain expression. Huh? Royal, that I heard it, that's why I said. Royal. So that's why I did not use that word. I wanted, that's why you use this word.
Actually, my lord, this is the section for which I am incarcerated.
Why you said it a royal? I just wanted to know.
The basic, I want to. Now, my lord, my submission would be before your lordship, 2 persons, there are 3 persons standing on the similar footing. Now, one differences of them.
The victim lady has been recovered.
Recovered, my lord, her statement was also recorded.
Statement has been
And
recorded.
yes.
Now committed to trial.
No, but
No.
Why?
My lord, the other accused persons
are on bail.
are on bail. my lord.
Then why his application for bail was rejected twice?
My
My lord, actually, your
serious allegation, your lordship. Kindly see
Where
the
is that
162
order?
statement. Kindly see the one.
But very good. Then why you are not taking steps? Why you are not taking steps? Everything is there. Then where is the difficulty in setting the trial in motion?
charge sheet was filed in the month of July 2022.
Charges have not been framed as yet.
That has not been committed even.
Really?
After the
What are
commitment,
you
the
doing?
charge will commence.
What are you doing?
Give us 6 months time, my lord.
6 months
No, my
time.
lord. We will conclude the trial.
My lord, one indulgence.
For
I'm
conclusion of the trial, hoping that the charges would be framed.
My lord, one indulgence I'm seeking. After lapse of 1.5 years, the case has not been committed.
Because they have a right to object. Then we do not know this Naraji petition takes how many days or months to get it disposed of.
If your lordship can take the page number 12, the last portion, submission of charge sheet 18/7/2022.
Lastly rejected on 12th of September.
12th of September.
So this is the 4th application.
My lord.
The 4th application.
Yes.
My lord. Only on the ground of
No,
inordinate delay, what I have no contribution.
But only thing is, what is going on? Charge sheet filed for the court has certain charges. When the charge sheet is filed?
Charge sheet filed on
18 July 2022.
What is this going on? Who is a CGM here? Which no, CGM Jalpaiguri?
CGM Jalpaiguri.
What is doing? 2022-23 has gone, 24. The second month is going to expire. What is doing? And such a serious matter.
takes 40 days, I'm drafting it. Without any contribution from my end, matter is delayed.
That's true.
But give us 1 month time, we will transfer the case, commit the case and
1 month they will take.
Earlier, 3 applications for bail had been rejected by this court, considering the role of the petitioner attributable to the commission of an offense for which the case has been registered, and after completion of the investigation, the charge sheet is filed. We do not find any change circumstances in between the interregnum period of rejection of the last application and the filing of the present one, except that there is no progress shown in the matter. The charge sheet was filed as far back as in the year 2022. Yet the Chief Judicial Magistrate Jalpaiguri has not taken any steps for committing the case for trial, committing the case to trial, for trial. It is really alarming that a person is languishing in jail for such a long period, yet has no ray of hope that the trial would commence. Though we would have inclined to grant the bail, but after taking into consideration the fact that earlier applications were rejected, and on perusal of the statement of the victim on recorded under section 164, we do not think that it is a fit case where the petitioner should be granted bail. Accordingly, the application for bail is rejected. However, we direct the CJM, Jalpaiguri, to take up the matter immediately and the commission commit to it. Sitting coaching immediately goes to commit the case for trial. Session, and then he will claim the charges. अच्छा लिखे ना की बोलছি however we direct that the jurisdictional court will take all utmost steps so that the trial is set in motion and to be concluded on or before to be concluded within 7 months from the date of the communication of this order. Sir,
My lord, that's an anticipatory bail, my lord.
maybe,
My lord, several other accused person nothing granted.
maybe. Why you did not mention in the morning?
My lord, yesterday it was mentioned.
It will come, don't worry.
But it's about upgradation.
What? We said that you give a notice to the other side, come, for 2 days we are open. Whoever mentions the matter will take up the matter, don't
Today
worry.
The matter is, my lord, listed as 159.
Please ensure the other side, no difficulty, come and mention, I want to do the matter, we'll take up.
Tomorrow.
Or even today we can take up, but ensure the other side.
Lordship.
Similarly, 159 item anticipated.
Please, please,
Lord,
please.
if other side is available.
Yes, yes, call the list. Huh.
Item 1.
Milord, I'm extremely sorry, Milord. I could not present myself, Milord, before your Lordship, but I am there virtually to assist your Lordship, Milord. Mr. Shah Poddar is there with a particular document.
Yes.
Milord, wherefrom it appears that, Milord, this issue regarding, Milord, this 2004 decision was placed before the Executive Council, and the Executive Council had taken notice of it. Milord, in the 25th Executive Council meeting held on 31st of May 2006. Milord, Mr. Shah Poddar, I am requesting him to hand over the 25th EC Council meeting, Milord, to your Lordships. Milord,
Yes.
kindly take page 2. Page
Yes.
2.
Yes.
In the meantime, the university administration, upon taking serious note on the series of instances of persistence defiance, in the facts of that decision, Dr. Chaudhuri, causing acute academic and administrative problems in the university, decided to adopt and implement the statute relating to discipline, penalty and appeal in respect of employees of BCKV, the parent university, the provisions which are still operative and effected at the parent university, and of the disciplinary rules, procedure or norms as are provided for employees of state government, whichever deemed considered appropriate for the purpose of lawful, speedy and clear dealing of cases falling under the categories of indiscipline, misconduct and cognizable offences under laws and rules of the state in general concerning the employees of the university through issuance of notification number 27 December 2004.
Yes.
When a point was taken, though not on the pleadings, but in course of submission, that this 27 December 2004 was not placed before the EC. We have in our affidavit in opposition to the main application.
Yes.
Milord, we have disclosed that this entire decision, whatever is going on, Milord, has been placed before the EC. Even, Milord, the charge sheet has been placed before the EC. If your Lordship so desires, we can produce documents evincing such facts. Milord, his grievance is that the charge sheet has not been issued by the EC but by the Vice Chancellor.
Yes.
So, Milord, the fact remains, though, Milord, I cannot show your Lordship, which is not on record. I cannot show your Lordship and I cannot improve on it. 27 December 2004, ipso facto, EC, Milord, in terms of 26.6, this is the only document which I can lay my hands on, Milord, overnight.
Yes.
I have requested that they have given me this document.
Yes.
And, Milord, I have also pleaded in my vacating application as well as in the affidavit in opposition to the stay application that, Milord, he has, Milord, refuted the charges by filing a reply to the charge sheet where he has not taken the points sought to be argued before your Lordship. He has refrained from participating in the inquiry on a different ground. His entire writ petition is based on the premise that the charges are vague and lacking in material particulars, which the Honorable Single Judge, Milord, did not allow, and the Honorable Single Judge allowed the inquiry to continue.
Yes.
Now, Milord, in appeal on the 30th and on the 24th of November, for the first time, Milord, an argument on the issue of jurisdiction has been raised, Milord, which we have dealt with in our vacating application, which, Milord, in terms of your Lordship's yesterday's observation, 26.2 and 26.4 ipso facto might not apply, but even then, Milord, 26.6, this is what I can, Milord, show your Lordship.
Yes. Yes.
Yes, this is in a nutshell, our case, and we have exactly pleaded whatever has transpired, and we also, we have recorded in the pleadings, filed by the university, that we are always willing and always will place everything on the EC to ultimately validate our decisions. The VC is not going to take any decision. It is at the stage of the inquiry report. The inquiry report is awaiting placement before the executive council.
Yes. Yes.
So, this is, on the question that has cropped up yesterday. Apart from that, I do not intend to cite any particular judgment, because, the judgments which are there, is on a different premise, not on BCKV and UBKV, two separate acts. Here, admittedly, Uttar Bongo Krishi Vishwavidyalaya Act does not have any disciplinary provisions. Your Lordship may record it. Uttar
Yes.
Bongo Krishi Vishwavidyalaya statute also does not have any disciplinary provisions. We have adopted in order to, ensure that discipline amongst the employees are maintained.
Yes.
And even the charge sheet was placed before the EC. That document today is not with me. If your Lordship, because these points, it was raised from the bar, we have dealt with it, and we have recorded that every document has been, routed through the EC.
Yes.
Page,
Yes.
paragraph AA of our opposition, we have recorded, even though the inquiry proceeding has been carried, the disciplinary proceedings in its entirety has not come to its finality, as it is still under process. In any event, all these acts, starting from initiation of inquiry till withdrawal of suspension, have all been ratified and approved by the Executive Council. We have stated that on oath, which he has not dealt with. He has been served with a copy of the affidavit, he has not dealt with it. Page 10, paragraph AA.
Yes.
Not,
That's all?
not appearing for the university on the issue of jurisdiction, your Lordship will kindly permit the university to, close the inquiry, or, put the inquiry to rest. It is at the stage of inquiry report, and he has not, disclosed the subsequent documents, which are appended to our vacating application, starting from pages 35 onwards.
Yes.
Pages 35 onwards. Whatever documents, is annexed, he has not disclosed it anywhere. He has merely, written to the inquiring authority without even raising the issue of jurisdiction. And he has also filed his response to the charge sheet, where also the question of jurisdiction has not been raised. His entire writ petition, as well as the memorandum of appeal, as well as the stay application, is premised on the ground that, he is questioning the charge sheet on the issue of vague charges.
Yes. Yes.
But it is a question of law. I am trying to answer your Lordship, that 27th December 2004 was taken note of, and we have been proceeding with various disciplinary inquiries in the university on the basis of 27th December, on being ratified by the EC, as I have shown your Lordship, the 25th EC resolution.
Yes.
Apart from that, I cannot show your Lordship any other document. I can show your Lordship, what? I can show your Lordship that all these things have been routed through the EC.
Yes. What has happened?
This is, in a nutshell, this is my submission.
Yes, what do you say?
First point, lords. The point that they have taken, my lordship, is that their affidavit in opposition and their plan to application has not been replied by us. I take a point of demurrer here, my lords. If I can have my lordship for a moment on either the affidavit in opposition or the CAN application, my lords will find that such affidavit in opposition or the CAN application has been filed by the assistant registrar. Now, the assistant registrar is was neither a party before the writ petition.
Oh, whatever, it's not, it's an affirmation done by him on the basis of an authority being being provided to him.
They should
You
have
can't,
at least
no,
filed
sir.
to appeal.
So, very good. Other forum, not in the High Court.
No. The second point, my lord, says that has been raised by them is that I have never raised this point before the disciplinary proceeding. If I can have my lordship for a moment in the affidavit.
No,
in
the only
opposition.
question, sir, the only question is that you have said that the EC being the appointing authority under the first statute, this is to be every action which is to be taken against the teacher should be done by the executive council, not by a vice chancellor.
My lordship.
So you have taken that plea that so far as the issuance of the charge sheet or the articles of charges are concerned, this is done by a authority not conferred power under the statute, so that has to go. Very basic question and very pertinent question in this regard. But to the which they have said that this part was ratified by an executive council and there is no difficulty in this regard. Now the question is post facto approval or a prior approval. These are the two issues which are there.
Yours, my charge sheet was never ratified by the EC.
Now, question is that if the action of the VC has been ratified by the executive council, will it not be deemed that the action is taken by the executive council?
If I can have my lordship for a moment on 26(7), which talks about the ratification of the steps taken by the vice chancellor by the EC.
Now, sir, the question, the entire writ petition hovers around a very small, I think, the arena. The arena is that the charge sheet is assailed by you. Till date, the inquiry or whatever, the inquiry has not been contemplated or anything has not been done. It is still at the nebulous stage of the charge sheet.
No, with respect, no. It has been proceeded with. It has been proceeded with.
Anyhow, we are concerned with the cause of action pleaded here.
Yes.
So it is
Correct.
concerning the charge sheet only. Now the question is whether the charge sheet issued by the authority is a competent authority, not a competent. I think that is the first and foremost question one has to look at. Your entire endeavor was that he is not a competent authority. That's the only point. So far as a vagueness, we do not find from the bare reading that a layman, and that too, I would not say a layman, a man who has acquired a knowledge, has an academic excellence, will not understand that what they wanted to say. The language is very clear. Whether it will be sustained or it will not be sustained is a matter of inquiry. The disciplinary proceeding that will be done. But at this stage, we have to confine to that. Vagueness, we do not find, to be very frank. I have seen the articles of charges. I do not think that it can be said to be vague. Only thing is adoption of an ordinance is the main question, and then applying that particular provisions of an ordinance in this regard. And what would be its impact if it contravenes the first statute or the parent statute?
The charge sheet here in Milords has been issued by the vice chancellor. Now the vice chancellor, Milords, as per 26(7), has to get it ratified through the executive council.
Correct. This is what they say that it has been
No, it
ratified.
hasn't been done. What has been done, in fact, Milords, that the appointment of the inquiry officer was ratified, not the charge sheet. If I can have Milords for a moment on the EC meeting. EC meeting, Milords, will find is in their CAN 2 application, Milords.
Sir, the only thing is, what they have ratified is that particular notification dated 27/12/2014. What is that notification? It's an ordinance which was framed under the B. Ordinance was framed under that B. What do you say? This is a Vishwabharati or whatever.
The ordinance is by the BCKV, Vidhan Krishi
Vidhan Krishi.
Vishwavidyalaya.
So they have adopted that ordinance. Now, if the ordinance is adopted, then the provisions of the ordinance becomes applicable. And if the ordinance says something, then in that event, one has to understand that how far that ordinance will, you have not challenged that. You have not challenged. I'm telling you very frankly, you have not said that there was no power conferred upon the EC to adopt any kind of an ordinance.
Giving the appointing
Or,
authority role to the
or
vice
if
chancellor.
the ordinance runs counter to the spirit of the the parent statute, then that ordinance cannot be said to be a valid piece of legislation. You have not said so. You have not.
No, sir, I'm on the second point. The charge sheet may not was issued by the vice chancellor. There is no doubt about it. As per
Ordinance-
26(6).
Now, ordinance requires a ratification or waiting from the executive council. Again, I'm saying, does it require? It does not say so. Ordinance does not say so. That's a very unique. That's why the first question I raised,
In that case, not whether the ordinance,
first question that I raised,
whether
taking
the,
into account all these things, I am really, I can't make any comment on that.
My lordship,
That's your conscious decision.
my lordship, whether the ordinance making power,
You can't raise that. You can't raise that.
no, because the statute says the ordinance making power is also with the state government.
I am again saying you can't say so. You have not challenged the ordinance.
Even if that is what the case may not
That is
say.
what I'm saying. I told you
I am
that that's the
assuming,
whole.
lords, I am assuming that the charge sheet was issued under the emergency provision. I am assuming, lords, that the charge sheet has been issued under the emergency provision. Because otherwise the EC has to issue the charge sheet. Now, even if it was issued under the emergency provision, then also not the proviso to 26(6) and 27 and 26(7), there is a ratification that is required to be done by
That
this.
is what they say.
No ratification has been done. What they have submitted,
Difficulty,
lord,
again, I'm saying the difficulty is that there is a provision. There is a provision. But the ordinance runs something differently and a different channel has been provided there. And
But
if
then
they
the-
have adopted that particular
ordinance-
channel,
the ordinance cannot be above the act.
sir, that's why I said that what you have done, you have not said anything.
But for a moment on 26(7) proviso and 26(7).
Maybe you are talking about, but they are proceeding under the ordinance.
No, but still.
But
that-
the
that
ordinance
has to be
says,
ratified by this.
ordinance says that it's a vice chancellor who will do that. The schedule is there. Everywhere the vice chancellor.
Because he is the appointing authority there.
Correct. So with the approval of the executive council and that approval, he says that.
For a moment, on
I've
26(6)
done.
proviso and 26(7)
Yes.
of the UBKB Act.
No.
Lord,
No.
clearly says that subject to the foregoing provision, the vice chancellors are give back to the orders of the executive council.
I know it, sir. But what about this ordinance?
And anything that is done under
And
26(6),
and is specific, that is more broader, the pass. And here there is a specific provision under the ordinance. How it has to be done? If those provisions are there, then what remained? I'm just asking this. Because admitted position is that this particular Uttar Bango Act does not contain any kind of a, the chapter concerning the
disciplinary process.
disciplinary proceedings. Now they have borrowed this. Now they wanted to proceed under this ordinance. Then show us from the ordinance that there is any infraction which has been done.
But even in
From the ordinance, we do not find any infraction.
even in the ordinance, my lord, the
Ordinance is not having a character or a flavor of a subordinate legislation. Mr. Mishra, is it not? Is it not? Is it not a kind of a I would say the subordinate legislation?
it is a subordinate legislation. And even the ordinance making power is not there with the vice chancellor.
Aha, then why, what you are doing?
No, I understand, no, then I have to tell
So
the.
I do not know. We are not assuming an advisory jurisdiction.
No.
We have to proceed that everything is to be done in this way. Then what can be done?
No, even in the ordinance law, there is a provision which says that it is only the appointing authority who is the disciplinary authority.
Appointing authority is a vice chancellor under this schedule
Malaship.
and with the approval of the executive council.
Malaship.
So that your appointment has not been under challenge or your appointment is not bad. But so far as the penalty and or everything, the proceedings are concerned, it does not say the ratification of an executive council. It simply says the vice chancellor. Look at it is only at the time of appointment with the approval of the executive council. But so far as the other disciplinary proceedings or other proceedings are concerned, no, there is no such provisions. Come at the schedule 1.
Malaship.
First, the appointing authority means the vice chancellor with the approval of. That's the only thing, appointment. You are not saying that your appointment is bad. You are happy that your appointment is good. And then there is nothing where the executive council is to be consulted.
If I can have Malaship for a moment on the definition of the disciplinary authority
Sir,
in the ordinance.
Sir, authority competent under this ordinance to impose on him that penalty, and the vice chancellor is the authority competent.
No, but the definition of appointing authority, Lord, 3-4.
Please,
Section
that's
2.
why I say appointing authority means an appointment to the post of an employee for the time being, authority empowered to make appointment. What more? What more? Only the paraphernalia is given that it should be with the approval of the executive council for the purpose of appointment. Nothing.
Lord, even if this charge sheet has been issued by the vice chancellor,
True.
he should have issued it under 26(6), applying the emergency
What
power.
I'm saying once the ordinance comes into play, then this ordinance has to be adhered to. It's a subordinate legislation where these paraphernalias, where the modalities have been provided.
It's a subordinate legislation wherein, Lord, the.
Then again I'm saying,
Rules have been changed.
I think again I'm saying, what you have done? What you have done? Are you not realizing that what you have done?
I understand.
Yes, then at this stage, what can we?
But my condition still would be, Lord, that the charge sheet needs to be ratified, Lord, by the EC.
That's not.
Which hasn't been done, Lord, in this case.
They can get it ratified post facto.
No, they cannot, Lord.
Oh, they
Because
cannot.
I can have my Lord for a moment.
They cannot.
On
Anyhow,
26
sorry, we are not going into that aspect. Because we find that every action has been taken here in terms of
the ratification has to be done immediately thereafter.
No. Immediately is a very, very vague term.
No, my lords, the other courts have held that immediately means.
Means 24 hours or 48 hours or?
The next executive council meeting,
Uh,
which has not been done in this.
There are judgments which says 24 hours. Sometimes it says under the Mohammedan law, when a right of preemption is claimed, there also the rule says immediately. That has been interpreted by various courts. Immediately means immediate jumping. Even a delay of 2 hours or 3 hours is a fatal one.
Here in lots, 5 executive meetings have happened. The charge sheet has never been ratified.
That I have also held in my judgment to that effect. Anyhow, it's a more a larger issue. It all depends what can be done. The problem lies there.
The ordinance has to be changed.
No, I am not saying that what is to be done. It is up. Your baby, you have to raise him in your own way.
I understand.
So yes, you have nothing to say except for ceremonial appearance.
My lordship, in that case, my lords,
Yes.
may I be permitted to impress upon my lordship that the charge sheet is vague?
You may impress, but we are not impressed. After looking at it, no.
Open mind, my lords, then lords.
No, we are, that's why we said at the very outset, so far as the vagueness, no, we are not happy. And if you say so, then we'll record that what is your qualifications and what is the language which is used. And you know the line of judgments that on a bare look, one cannot assimilate that what point he has to meet. It's so vague. Can't you understand what he really wanted to say?
I have written an email to the chancellor.
That is again, Mr. Vishro, you are going into the merit. Again, whether this action would tantamount to a misconduct or will not tantamount to a misconduct will be decided by an inquiry officer and ultimately in a proceedings. There is no difficulty in this regard. At this stage of charge sheet, one has to understand.
Lord,
We will
I have a judgment that says, my lord, that the emergency power, if it is not ratified in the next executive council meeting, then that cannot be looked into.
Again, then we'll have to distinguish that judgment on that score once the ordinance has come in place.
The ordinance, my lord, was adopted in 2004. Even if the contention is taken to be correct, it was
2006.
in 2006.
Correct. But your action has been taken, your steps have been taken after 2006. Is it not?
But then, my lord, there is a judgment that says that 11 months is too much older time to take to get it ratified from the executive council.
Sorry, you are not.
To be done
You have not taken that.
No, Lord. Even in the 30th November.
Sorry, we can't. Sorry, we can't. এটা দিয়ে দাও আমি dictate করে দেব এই tomorrow for judgment.
Grateful, dear Lord.
I'm deeply.
And for your lordship's kind assistance, my lord, page 17 of my can will show that it was placed before the EC. Grateful to your lord.
Lordship, I'm praying for Passover.
Thank you.
Yes, sir. Which one?
I want to state your lordship.
Yes. From which mine you exhumed all these NDPS cases, only NDPS cases? Yes. What is this? Commercial quantity.
My lord.
How much?
51.
22.
Oh, where? From
Mother and son.
oh, this matter was taken
Yes,
up last
yes,
time.
Column number 10 of the arrest. I handed one earlier on the government, signed by the lady constable. And lordship also
No, my lord.
on this score, her
Column number 10 was signed by the independent witness.
That is the Roshan
Roshan
Paswan.
Paswan. His statement was it was
No,
increased also.
Madam, I have the certificate copy, my lord.
Sir.
Madam, kindly see, madam, kindly see,
For the number 11.
madam, kindly see, I have
Oh,
the certificate
madam.
copy of the arrest.
Huh? Sorry, it's not that. Signature of the arrestee is Lady Constable.
Yes, madam.
Shushmita Mohan, what is this? Lady Constable. LC.
Yes, very good.
Next.
No. Look at it. What is this? LC. Oh.
Actually, they have made a mistake. Actually, these witness, it should have been before that, and the signature of Smita might should have been at the bottom.
Where do I get a statement?
Statement is there, page number
56.
56.
Technical error.
Small.
Page.
Page 56.
I do not know small or fatal. Page
Page 56, my lord.
56.
56.
I can't read that. I do not know if he is speaking in Hindi or something, then why in English those are recorded? This is, I think, the rampant here in this particular zone. What is this? What? Can you read?
Yes.
I do not know. Younger generations using lot of WhatsApp and this one they can. What is this?
आपको बताना चाहता हूँ कि उस दिन को मुझे दीपंकर साहब ने
इधर कॉलोनी को के लिए बुलाया, अंकल आया मुझे
No. No, either you write, either you write in Hindi, one can understand, or in Bengali, or if I do not know in English, you are using the English script and then writing in Hindi. I do not know. It's very difficult.
Such line over the
हिंदी तो लिखे था ना ये अच्छी असुविधा
161
मैंने सीधर भी साइन किया
The counsel for the petitioner submits that there is a serious lapses which are fatal in nature, as in column 10 of the memo of arrest. The reading officer have obtained the signature of a lady constable, which is not, who is not an independent witness nor a member of the family or the respectable person of the locality. According to him, such lapses is always considered seriously, and in fact, the coordinate bench in case of Shainur Bibi, alias Sainur Bibi and another, versus the state of West Bengal in in CRM within bracket NDPS number 428 of 2023, decided on 27/7/2023, have granted bail to an accused from, despite the fact that the contraband above the commercial quantity was recovered from his possession. The counsel for the state submits that because of the technical mistake, the petitioner cannot reap the benefit therefrom, as it would be evident from the record that the signature of an independent witness was secured on the said memo of arrest. It is further submitted that the technicalities cannot be projected as a fatal mistake inuring to the benefit of the person who have committed a serious offense. Full stop. We had an occasion to peruse the case diary containing the memo of arrest. It is no doubt true that in column 10, no doubt true that on the right hand side of the column 10, the name of the lady counsel and her signature is put thereupon, where in the column pertaining to a counter signature of the arrestee, the name of an independent witness, namely Roshan Paswan, is appearing. If we go by the ipse dixit of those columns, the column 11 relates to a counter signature of the arrestee, which of the arrestee, and the name of a independent person is beyond the conceivable imagination. as it must contain the signature of an official. The case of Sainur Bibi Supra cannot be applied in an abstract manner unless the court finds a parity in facts in order to cull out the ratio laid down therein. It appears therefrom that the name of the lady counsel and her signature was obtained by, on the right side of the column 10 of the memo of arrest. But it does not appear from the said judgment that there was any signature obtained on the right side of the column 11 thereof. Stop. Our attention is also drawn to the statement of the said Roshan Paswan, who clearly stated that he put his signature on the Caesar list as an independent witness. The expression Caesar list has been extracted by the counsel for the petitioner as a bonanza in contradiction with the memo of arrest. It is sought to be contended that such person put his signature in the Caesar list and therefore not in the memo of arrest. Any statement made orally, if belied the documentary evidence, the documentary evidence would prevail. A layman who does not know the distinction between a Caesar list and the memo of arrest, having uttered a word, the court must take a pragmatic view. Where is the Caesar list?
Caesar list.
Take a pragmatic view. Stop. Whether the said witness has signed, has also signed on a memo of arrest, apart from his putting his signature on the Caesar list, is a matter of trial, as we are not in a position to not in a position to take a conclusive decision on the veracity and the authenticity of the signatures put by the said witness. Furthermore, if the technicalities is pitted against a substantial justice, the latter must prevail. Admittedly, the contraband above the commercial quantities recovered from the possession of the petitioner, and in view of the embargo having created under Section 37 of the said Act, we do not find that the grounds as urged before us invites an exception to be taken in this regard. Accordingly, the application for bail is rejected.
I'm grateful to your lordship.
What is the seizure this? वो घंटे के deny the government was executed on the at this stage I'm giving. Yes, call the next.
For this time, lordship.
Yes. NDPS.
Commercial quantity. Evidence date has been fixed first March.
This is the second application. This first application was dismissed on 22nd September. Look, this is the second application for bail at the behest of the petitioner. The earlier application for bail being CRM within bracket NDPS 703 of 2023 was rejected by this court on 22nd September 2023. It is recorded in the said order that the commercial quantity of contraband was recovered from the joint possession of the petitioner. And even if he's in custody for a considerable period of time, it does not instill a confidence upon the court that there is no possibility of committing the offense again, which is one of the exceptions carved out in section 37 of the NDPS Act. We do not find any changed circumstances in the interregnum, nor we find that any case has been made out warranting the reconsideration to be made in the instant application. The application for bail is thus rejected. However, what is the charge sheet submitted?
First March is date fixed for evidence.
However, it has been informed to us that the 1st March 2024 is the date fixed for recording the evidence of the witnesses, and therefore we hope and trust that the special court under NDPS Act shall make efforts to bring the case to its logical end as expeditiously as possible.
Grateful, lordship.
Call the next. That he will not commit.
Lordship, I beg to appear for the petition.
And that is not to commit the offense while on age that it does not exist. Exception. And is a conjunctive word, I know. No.
Lordship, I beg to appear for the petitioner, Lordship. Lordship, this.
Why you beg?
I beg to appear for the petitioner. Lordship.
Why you beg? Why you are using a colonial expressions? You have a fundamental right to represent your client. You can say that I am appearing for the petitioners. You have a right to represent.
I am appearing on behalf of the petitioner, Lordship.
Yes.
I apologize. Lordship, this is the renewal of bail application pertaining to an NDPS matter. Lordship, before I proceed with my grounds,
when it was
Lordship, it was
lastly
rejected.
This is the third.
Yes, Lordship, this is the third application. However, Lordship.
Lastly was rejected.
22nd of November 2020.
No, it was not rejected at that point. It
Just
was not placed at that
23rd?
occasion,
Just
Lordship.
1 minute. 3rd
of August, Lordship.
2nd of November.
November? No, we do not find. We find the order of 23rd August.
Lordship, if I may, on
Just 1 minute.
Correct.
That was dismissed as
Then-
not dismissed.
No, that was 21st. Then there was a 21st August also.
Yes, ma'am.
No, the same matter. No, it was the same matter. Just 1 minute.
Same matter.
Then is a 5th June is an earlier application.
Yes.
That was rejected.
It's the fourth time.
This is 298. No, there is another 298. Which is directed to appear on 12th of in the next circuit bench. What has happened to this?
Lordship.
298 of 23.
298. Lordship, this is 19 of 2020, Lordship.
I am talking about 298 of 2023.
29. Lordship, out here, as per my petition there, it has been rejected on 2 occasions. That is 5/6/23, 23rd of August 23, and on 1 occasion, that is 22nd of November 2023.
What is that number of the case?
Lordship, the number of the case is, Lordship,
No.
19 of 2024 CRM NDPS.
NDPS 298, 12/4/2023 se আছে on the prayer of the representing the matter again in the next circuit bench. It is pending. সেই জন্য জিজ্ঞেস করছি। What has happened? Earlier যেটা হয়েছে সেটা 565 একটা আছে আর একটা 298 আছে। Oh, sorry, 298 was also dismissed. Anyhow, that was on 5/6. Yes. Then last.
Lordship, on last, it was not praised on the occasion of, if I may, Lordship, 8/38 of 2023.
So 3. This is the 4th application.
This is the 4th application, Lordship. However, Lordship, if I may, Lordship.
Yes.
Yes. Lordship, before I proceed with my grounds of my case, I am relying on 2 grounds. But before that, if I just made the gist of the fact is that I have 23.6 kgs were seized from me, out of which the total contraband that was seized from me, it was seized from 2 separate bags. One bag contained 12.5 kgs, the other contained 11.1 kg. So total of 23.6 kgs. And it was seized from me in the month of November 2022. Thereafter, I have been, at the time of filing of this application, I have been in custody for 424 days. Currently, it is around 450 days. Now, Lordship, the charge sheet of this case has already been filed back in the month of January 2023. And charge has also been framed on 5th of April 2023. Thereafter, Lordship, to begin with my with the first ground of this bail application, Lordship, there are 15 witnesses total of 15 witnesses, and out of those 15 witnesses, Lordship, ever since the framing of the charge on 5th of April 2023, 2 dates of evidence has passed. And on those 2 days, one of those days, the witness did not turn up. The other date, that was in 9th or 10th of January 2024, on that date, Lordship, the witness did turn up. However, after a prayer from the prosecution, that was subsequently deferred. Lordship, I have a copy of the certified copy of that date.
The next date is fixed on 3rd of April 2024.
Why your public prosecutor asked for a time?
If I may, Lordship.
Why? When the witness turned up, why he asked for a time? No, 10th of January, it was taken up. There were documents were marked as an exhibit.
Yes, Lordship, it was taken up. It was the chief examination of the witness was done. It was done partly, Lordship. It was not done completely.
Correct.
It was partly done, and
You
there
say that at the request of the prosecution, it was not taken. What? Not...
Yes, Lordship, I apologize, Lordship, but what I meant was that it was the chief of the witness was
Whatever,
part leader.
anyhow, the examination in chief was not complete.
Yes, it was not complete, Lordship.
Then,
Thereafter, Lordship, this is the first ground that I'm relying on. Ever since April 2023 till January, not a single witness has been completed. That concludes my first ground. The second ground that I have, Lordship, this is a copy of the certificate by the magistrate that was done 3-4 days after the subsequent to the search and seizure of the alleged contraband. Now, Lordship kindly comes to line number 7, an observation by the magistrate, Lordship. Copy. Lordship, it says the said bags found to contain a contraband item after weighing 10.420 kgs, and the exhibit B, that is bag number 2, contains 10.40 grams, 10 kg 40 grams, a total that amounts to a little bit of 20 grams, 20 kgs. Lordship, at the time of search and seizure, it was categorically mentioned in all the documents that has been given. It has been mentioned that it is 23.6 kgs. However, at the time of certification by the magistrate, which occurred 3 or 4 days, the search and seizure happened on 13th and possibly on 17th.
We'll take steps against them.
All right, Lordship.
Where the rest of the contraband gone? We'll take
Lordship,
care of that.
Lordship, there has been a total of discrepancy of more than 2.5 kgs, Lordship. Now
that will take to task. Take them to task. Don't worry. All these officers, they have to be. We will direct the investigation to be done against them. Where 2 kgs have gone. Consumed or what?
Lordship, on that ground, Lordship, if I may. With the permission of the Honorable Court, Lordship, I have referred 2 judgments. However, Lordship, it is pertinent to mention here, these 2 judgments belong to Bombay High Court and they are passed by the Honorable Single Bench. However, Lordship, it's the principle that I am willing to abide in this instance, Lordship, if I may. Lordship, this is Lordship, if I may, Lordship, it is Jimmy Amuzu versus the Narcotic Control Bureau. The operative part, Lordship, paragraph number 17. This is a judgment passed by the Honorable Single Bench of the Bombay High Court. Lordship, operative part, paragraph number 17. Learned counsel for the applicant would also invite my attention to one more glaring discrepancy in the sense the seizure Panchnama Qua, the contraband dated 1st of December 2020 reveals weight of contraband as 118 grams. However, during the proceedings under section 52A of the NDPS Act, when the same was weighed, it came to be 100, 103, 52, and 103.3 grams, thereby showing a significant difference of around 18 grams or more. The counsel would argue that in view of the said discrepancy, tampering with the alleged contraband cannot be ruled out. Now, Lordship, this is the first case that I'm referring, and in this case, Lordship, was also one of the grounds on which this petitioner, who is a Nigerian national, he was granted bail by the Honorable Bombay High Court, Single Bench of the Bombay High Court. Also, Lordship, there's another case on the very same ground which I'm referring. Lordship, this is also from a single bench of the Bombay High Court, unfortunately. Lordship, this is the Lordship, this is the operative part is paragraph number 6. At the time of seizure on 16/4/2022, the applicant was found with the contraband charas of 1 kg and 10 grams. After the period of 59 days in compliance with the provisions of section 52A of the NDPS Act, samples were drawn before the Learned Metropolitan Magistrate 64th Court, Esplanade, Mumbai, and in the presence of the magistrate, the weight was contraband. Present applicant is concerned, samples found to be 1 kg. 1 kg of charas will have to be regarded as intermediate quantity. And in this case also, Lordship, the applicant in this case was granted bail. Now, my Lordship, my humble prayer is that, coupled with this fact, nowhere in the certification given by the magistrate is it clear, Lordship?
Do you think that 2 weighing scales, if you put the same article, will give you the same weight?
Lordship,
if you put 2 or 3 weighing scales simultaneously side by side and put the same article in each of the weighing scale, what do you think? It will give you the exact weight.
No, Lordship, it will not. But then there won't be a discrepancy of 2.5 kgs or more than that.
Here was a 10 gram only.
Yes.
And the variation is well known.
Yes.
The way it has to be put, how it is to be done. And at the time of Caesar, they carry certain weighing scales. And there, on the spot, they have to weigh. And thereafter, what is done? When they come back, there may be a variation. And minor variation, I can understand it. This is a case of such minor variation. 10 grams, negligible. When you put it, the heavy weights of kgs.
Lordship, if I may, Lordship, I humbly accept the contention of your Lordship. But Lordship, there is a discrepancy of more than 2.5 kgs.
No, significantly. Yes. Yes, continue and conclude.
Lordship, that's my submission as of now, Lordship. And also, Lordship, one final point. In the certification by the magistrate, nowhere is it clear that whether the weight of the total contraband, whether combined, if combined, whether that is net weight or gross weight. And as we know, the commercial quantity is 20 kgs. So at the time of certification, it has come 20.2 kgs, if I'm not wrong, 20.2 kgs. So if it is also coupled with the fact that nowhere is it mentioned that whether it is gross weight or net weight, Lordship, there is a very good chance and a probability, Lordship.
Conserve this energy at the time of trial.
Lordship,
conserve the energy at the time of trial. Do it.
Lordship, I also not have any other criminal antecedents, Lordship.
Whatever your earlier applications have been dismissed.
Lordship, may I seek one intelligence, Lordship, one last intelligence.
We will expedite the trial.
Yes, Lordship. 6 months, Lordship.
Yes, we can. This is the 4th application at the behest of the petitioner seeking a bail in connection with the aforementioned case, despite having found to have possessed the contraband above the commercial quantity. Earlier, a point was raised before this court at the time of moving the bail that there has been a violation of the standing order number 1 of 1988, and therefore the petitioner should be granted bail. So the court, this court, while rejecting this application for bail, held that the violation of the aforesaid standing order is a matter of trial, and therefore, if raised, shall be considered. Subsequent application does not yield any favorable result to the prisoner. To stop. This time, a plea sought to be raised that if there is a variance in the total weight of the contraband, then it raises a reasonable doubt that the petitioner has committed an offense. Stop. Our attention is drawn to the single bench judgment of the Bombay High Court in connection with Jimmy Amuju versus Narcotic Control Bureau and another, within bracket criminal bail appeal application number 61 of 2022, decided on 5th February 2024. That was a case relating to a cocaine allegedly found to have possessed by a Nigerian national. It was it was recorded in the seizure list that 118 grams of such contraband was recovered. And subsequently, it was found that that at the time of taking steps under section 52 capital A of the said act, the weight was shown as 100, 103, 52 and 103.3 grams, which the court found to be a significant variation, leading to a reasonable belief that the applicant therein is not guilty of such offense. The variation in the said case was found to be significant. And if the court has applied its discretion, such discretion may not be accepted in the event the court finds a significant difference in the facts involved in the given case. In the instant case, the earlier three applications were dismissed, were rejected, and the court did not find any ground to take an exception to section 37 of the NDPS Act. In the instant case as well, we do not find that taking into account the total weight of the contraband as shown in the seizure list, sees a substantial variation at the time of taking steps under section 52 capital A of the said act. Even if there is a variation, it is a matter of great concerns with regard to the officials who shall be answerable for such variation, and for which an appropriate explanation must be asked by the higher officials. We are not able to countenance the view of the single bench of the Bombay High Court that the variation in weight leads to a reasonable doubt of commission of an offense, when admittedly the contraband above the commercial court's quantity is recovered from the possession of the accused. We thus do not find that the petitioner can take any assistance of the view expressed by the single bench of the Bombay High Court in Jimmy Amuju. So, in view of the fact that earlier three applications were rejected, we do not see any changed circumstances, and therefore the present application is also dismissed. We have been given to understand that the case is fixed for evidence in the month of April 2024. We therefore request the learned special judge under NDPS to make endeavor to bring the case to its logical conclusion within 6 months therefrom, in accordance with law. Yes.
Oblige, Lordship.
একটা জিনিস আমি যেটা দেখলাম ওখানে 500 গ্রাম নিয়েছে, আমার এখানে দেখা যাচ্ছে 480 গ্রাম আছে। CO তো হচ্ছে is the commercial quantity. It will bring doubt যে commission আমি তো ভাই মানতে রাজি নয়। ওটা 50 ওখানে যে টোটাল গ্রাম করে ওখান থেকে একটা নিয়ে টেস্ট করবে তারপর সিল করে দেবে সেটা তো আছে আমরা এই ব্যবসায় এটাতে এর সঙ্গে কি সম্পর্ক আছে ওখানে বলছে 118 জায়গায় 103 দেখাচ্ছে 103 যখন দেখাচ্ছে which is actually a commercial quantity আপনি যেটাই না Next.
My lord, I am for the petition. Actually, my lord, this case relates to 6 of POX. Now, my lord, kindly
23, 24 and 26.
Only is a very confusing word.
My lord, I am not ready with the matter, or properly ready with the matter. I'll do tomorrow, my lord.
People evidence level.
In this
তুমি বলবে নাকি বলবে তাহলে আমি করবো যদি না করো তাহলে বলবো বলবো
Yes.
In this matter, my lord,
I'm for the petition.
the schedule of trial has been framed. Yesterday was date for my lord witness, today also. My lord. Up to 28th of my lord February, schedule has been my lord framed for deposition.
28, 25, 26. If possible, my lord, if possible, subject to your lordship convenience. Matter may be fixed up to 28, my lord, because evidence is on.
On the prayer of the petitioner, let this matter be listed in the next circuit.
Because I have the certified copy of the PW1.
Yes.
But I am for the petition. My lord, the matter pertains to my lord, post-poll violence. My lord, during the course of my lord, the last 2021 assembly election, my lord, few subdivision within the district of Coach Bihar, my lord, had become, my lord, the epicenter of all political turmoil. My lord, this is, my lord, this instant complaint originate from the said, my lord, political turmoil.
Should we take up?
My lord, kindly have a look on page.
ওখানে বলেছি যে respective FIRs গুলো করতে and then the matter was delegated to a decision bench. এখানে chief magistrate মনে হয় না solution Yes.
But kindly come to page 21 of my application.
Page?
Page 21. Lord, this order contains, my lord, the few of the accused persons have been enlarged on bail by the learned court below. But kindly have a look, my lord, the observation.
Yes.
My lord, the last paragraph.
Page 20?
My lord, page 21.
Yes. Who was conducting this case in the court below?
The prosecutor.
Have you seen that because of your default, he has been granted bail?
No, my lord, this was before CBI took over.
Oh.
Because it was only after the larger bench directive. CBI took over investigation.
Yes, sir. I've seen that.
No, look,
The state since last two occasions did not produce the case diary. Nothing was done. The court got, the Jalpaiguri judge got annoyed and then he granted the bail.
Page 16, my lord. It
Now the
reveals from
investigation,
their
now the
investigation,
investigation is with them.
lordship,
So
my lord, it reveals from their investigation as and when, my lord, the CBI took over the entire investigation from the state authority, my lord.
correct.
My lord, that one Hakim Mia is the principal, my lord, perpetrator, who, my lord, hurled bomb and, my lord, inflicted injury upon the deceased victim. My lord, these particular petitioners, along with those, my lord, the accused persons who have been granted bail by the learned court below, my lord, they have been entangled only with the, my lord, allegation that they were the part of the unlawful assembly and nothing else, my lord. It is the Hakim Mia, my lord, who is the principal, my lord, perpetrator.
They have taken over now. They must have been doing a lot of investigations, and the investigation may reveal certain more the complicity, and they must be doing it.
My lord, investigation has already over, my lord.
So,
Investigation has already over. Charge sheet has been filed. And from their investigation, my lord, it shows that, my lord, that Hakim Mia, my lord, is the principal, my lord, assailant.
let us hear him.
Who, my lord, orchestrated the entire crime.
Where is Hakim Mia?
My lord, he is in custody.
He's in custody. Here and now.
And my lord, kindly come to page 16, my lord.
And you were the accomplice of the Hakim Mia.
My lord, it is their allegation, my lord, that I was, my lord, this particular petitioner was the, my lord, the bystander at that particular, my lord.
When the bombs are being hurled, you are a bystander there. Somebody would immediately flee away from the spot.
My lord,
for the sake of his life.
My lord, the incident took place on the date of, my lord, polling. So, my lord, there was a huge, my lord, political turmoil. My lord, only due to, my lord, political revenge, my lord, these petitioners have been, my lord, arraigned in this, my lord, prosecution case. And, my lord, the CBI took over the investigation more than after 3 months from the date of incident. Only on the basis of, my lord, 161 statement, my lord, they have arraigned those, my lord, these particular petitioners, my lord, along with others. So far, my lord, this particular petitioner's role is concerned, my lord, he was, my lord, only a member of unlawful assembly. He was not the, my lord, actual perpetrator or assailant. My lord, it is, my lord, clearly reveals from their investigation reports, my lord. And, my lord, the person who have been granted bail by the learned court below, it was, my lord, the observation of the learned court below, my lord, that no overact was, my lord, found on the part of those persons who have been granted bail. And, my lord, these particular petitioners were standing on the same footing,
So
my lord.
let us hear him.
Lordship. But
That was a pre-CBI took over
Lordship.
the entire investigation stage.
Lordship.
Let us see after that he took over, what is the role, what he has found. Let us hear him.
My lord, this allegation, my lord, this
We
particular
appreciate
petitioner allegation.
What transpires is before it was transferred to a CBI, all these things has happened.
No, my lord.
The bail and all, everything was granted prior to the CBI took over.
Absolutely not, my lord.
I do not know. That
My
was
lord, No, my lord. No, my lord. My lord, they have granted bail on, my lord, 14th of, my lord, March 2023. CBI took over the investigation, my lord, much prior of that, my lord.
Let us hear him. Let us hear him.
It's absolutely clear from the, my lord, court
Let us-
order, my lord. My lord, this particular petitioner, after the incident took place, after Ananda, the poor man, was gunned down and bombs were hurled, he fled away. Only after proclamation was issued, we could pick him up. What are charges in the charge sheet is also read with
It's only the proclamation was.
so innocent that we have to issue a NPA, WPA against him. But before that, 41
That was allowed.
I do not know, my lord, but he was subsequently picked up by the CBI. Now, my lord, the charge sheet is ready. We are waiting for the DM to give us sanction to prosecute these people under Arms Act and Explosive Substances Act. We are running from pillar to post. The DM, either he is busy with law and order problem, or he is getting transferred, or he is not in the file.
Does it require a waiting of the DM?
My lord, he is the person who will give the sanction to launch the prosecution.
under Arms Act and under the Explosive Substances Act. Had we obtained the sanction, my lord, trial would have been in full swing.
Since when the sanction is not?
Last 2 years. We have
My lord,
been
I have
fighting
been
to get-
languishing in custody, my lord.
Even my lord, our department has written to the DM on 13/9/2022 and 4/10/2023, 6/11/2023, 20/11/2023, 16/1/2024.
Well, it is there.
All other
procedural
cases, my
actions, my
lord,
lord.
the trial is in full swing, but we are handicapped because of the sanctions. 302 read with 27/26 Arms Act, 3 and 4 Explosive Substances Act, 149 is also there. So no overt act is necessary for him to do.
My lord, before
My,
that.
my lord knows this very well. As per the settled position of law, once 149 is clamped in, overt act is not necessary.
My lord, I
But
was.
because of this sanction, my lord.
My lord, I was issued 41A notice, my lord.
He didn't come.
So, my lord, I put this question to myself that when 41A notice was, my lord.
Did you comply?
My lord, that was not complied. That was my fault.
Then
My lord,
what?
My lord,
What?
my lord, I put this question to myself that when 41A notice is, my lord, issued, to whom, my lord?
It is not 6-10, not twice. মৌসুমী সমাধান কেন্দ্র না জানি আনন্দ করো কোটেশন এগুলো করবো
Lord, may I, my lord?
And lordship, there is also 164 statement that he was there, he was taking active part.
My lord, the 164 statement has been, my lord, taken after more than 4 months.
Because the investigation was
And it
given
is-
to him after 3 months.
Lord, it requires to be corroborated by virtue of article, section, my lord, 145 of the Evidence Act.
Can you
In the
give
course
me
of trial.
those letters that
Why I should be, my
those
lord?
that addressed to DM?
Lordship,
Can you give me those letters addressed to the DM?
my lord, then allow me to come back tomorrow with the letters.
Sure.
My lord,
Sure. Keep it tomorrow. We'll consider definitely, but we are also very surprised with this fact.
but only one thing. My lord, 41A notice was issued in my favor, along with, my lord, other accused person. My lord, I put this question to myself that when 41A notice has been issued, when, my lord, the allegations
I
against
put
me.
a question.
Lordship.
Suppose a investigating agencies give you a notice under section 41A.
Lordship.
What is the purpose that you come? They wanted to put certain questions. They wanted to make
Lordship.
to take certain informations. They may question you. They may investigate you. Whatever. If they think that there is any element which is there, then they will definitely take steps in this regard. A person who is a law-abiding person like you, your client, such a law-abiding person, he was simply standing by the side, have nothing to do. He was simply watching the show which is going on. And then he did not comply that requisition of 41A. He did not make himself available to interrogating or investigating agencies for a pretty long time.
Lordship.
There was nothing which was done in relation thereto. They were now chasing or they were trying to get your whereabouts for months together. Ultimately, they have to go and pray for issuance of the warrant, the warrant of the proclaimed absconder.
Lordship.
Then they could anyhow manage to get you.
Lordship.
Now you say 41 notice, once it is given, then for all time to come, you cannot be arrested. Even if you abscond, unless they give a further 41A notice to you. Is this a law? Let me understand the law.
My lord.
If it is
I am
applicable,
not on that aspect, my lord. It was my blunder that I didn't comply, my lord, the 41.
then who is to pay
My lord,
for the blunder?
my lord, for which,
Can
my
you
lord?
reap the benefit of a blunder? Why you did not? I can understand on that day some problems. You could have gone subsequently. You could have gone there.
My lord, I
There was nothing.
presume that, my lord, they have been, my lord, scared about, my lord, the CBI, my lord. Maybe.
Sorry, nobody is
My lord,
scared
what
about
that, my lord?
it. Is always an investigating agencies, be it a state, be it a CBI, be it anybody. It is an investigation is going on in accordance with law. Every law-abiding citizen has to follow the law.
My lordship.
So, irrespective of what investigating agency it is.
My lord, for that, my lord, I have been languishing in custody for last, my lord, 9 months, my lord.
Anyhow, we'll consider the merit definitely, but this is something which is alarming to
We
me.
have one letter with us, that is 16/1/2020.
Show us the hard copy.
My lord, we'll bring it.
My brother has more experience of the trial court than me. He says, I do not know, WPA can only be issued when WA is unexecuted.
Yes, my lord, there is a procedure.
So why? Why you did not?
Lord, that cannot amount
That
to.
cannot.
My lord,
Anyhow, that's a conduct.
guts in
We are
it.
not keeping this in mind. Anyhow, yes. Come. Yes, call the next.
My lord, I am on behalf of the petitioner. I am behind the bar since 22nd.
What was seized from you, sir?
Heroin,
How much?
2 kilo.
2 kilo.
Allegedly. And we have filed a petition 58 under section 58 of the NDPS Act in there. My lord, actually, please see page 3, P3, page 13, P3.
You are 3 persons, Muhammad Mubarak, Rahul and Ohedur.
Yes, my lord.
Ohedur's, it was rejected. Then Muhammad Mubarak.
First time.
First time. And what about Rahul Sheikh?
Rahul Sheikh, filed and not paid.
This is another, we don't know. What is this another?
I've given all that.
The last occasion, Lord, was pleased to directly produce all the order sheets of the trial court, showing the progress of the trial court. This is the last order.
Yes, yes, sir. What is the ground?
My lord, actually, 3 persons are on bail. I'm in same footing. Actually, 4/1/2022, a direction is given within 18 months. And further, I've given a judgment, my lord. There 3 months was given, but they taken 6 months. Only 4th time was witness fixed for the evidence, but no one come and give evidence, my lord.
Why it is not done, sir?
And
Lordship, witness number, there are 13 witnesses in total.
Correct.
It speaks for examination of the 10 witness now.
When?
Next stage is.
my lord, my submission is that it is mandate of constitution. It is.
No, I understand that within a certain time when the court directed, they have not concluded the trial within that time.
Not only that, previously 4/1/2022, 18 months was given. and 3 month was given later on. And today's 6th month is over. And within 6 months, within 6 months,
Who is the learned judge? We are directing him to submit the report in this regard.
and two independent witnesses are hostile in this case.
What is going on when the court on three occasions have said that please conclude it? Will he not? Let him give explanation tomorrow, today itself.
So it is mandate of law. It is Sam putting.
It is really
And I'm
alarming
heard the
that,
word since long.
it is really alarming that despite these several requests having made by this court to conclude the trial within the stipulated time, there is no attempt shown by the learned judge, special court, to show respect to such mandate. The trial is unnecessarily delayed, and the right to have the speedy trial is one of the fundamental rights enshrined in the Constitution of India. Considering the above, the learned judge, special court under NDPS is directed to give an explanation by tomorrow, when this matter would be taken up at 12 noon. Let this order be communicated by a registrar of the circuit bench of the Jalpaiguri to the concerned judge. He is here, Jalpaiguri, concerned Siliguri, concerned judge immediately. Explanation. Ekhuni type korun, soi koran. Ekhuni. Go. Tomorrow at 12 noon, we have to rise for one.
They got that too.
Yeah. At Khuni Dao. Other side is here. Give it. 185 to bar করো আগে বলেছিলাম ওরা যে মেনশন করেছিল আলাদা করে রাখতে come tomorrow we'll see to it whatever you mention আজকে কি কতটা correct কালকে ফার্স্ট তিনটে এটা তিনটে
152 also is I have mentioned
152 দিয়ে
anticipated 152 আমি মেনশন করেছি হচ্ছে
whatever you have to